right, good morning, counsel. Back on the record in the Simpson matter. Defendant's again present with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Douglas, Mr. Bailey, people represented by Ms. Clark, Mr. Darden. Matter is here for motions to quash certain subpoenas, and the court has also issued its ruling regarding the renewed Pitchess motion, which should be pretty much self-explanatory. And Mr. Douglas, Ms. Clark, as soon as the custodian of records comes, because I'm ordering the disclosure of certain items, however redacted, for certain content, which will take some time. All right. I anticipate, however, that we'll be with Detective Lang and Mrs. Goldman perhaps for the morning session. All right. All right, let's proceed then to the motions to quash subpoenas. All right, good morning, counsel. Your appearances for the record.
Stephen Warren Solomon, Saltzman, and Jameson for Michelle Abdaran.
Good morning, Your Honor. Melvin Douglas Sachs for Kathy Randa.
All right, counsel, who wishes to go first?
I'll begin, Your Honor.
All right, good morning, counsel.
May it please the court. We as citizens do not give up our rights because Mr. OJ Simpson or anyone else is accused of a crime in this case. My client, Michelle Abdaran, is not a defendant in this case, is not accused of any crime, is not involved in any wrongdoing. She's only listed as a witness for the defense in this matter. My client was a housekeeper for Mr. Simpson's family in 1988 through 1990, from 1990 through back through up into and including the early part of 1994. Thereafter, she left the Simpson employment, went to work in a residence in Beverly Hills as a housekeeper. The district attorney's office, in its present form of the subpoena, if left untouched, would allow anyone at any time to get anyone's records. Let me look at the approach that the DA has taken in this case. First of all, Your Honor, on November 10th, they issued a subpoena. The subpoena was from November 1st, 1994 through February 10th, 1995. As the court can see from those dates, the commencing part of the subpoena was 4.5 months after the homicide. The subpoena was returnable on the 24th in this courtroom. As required by civil law, since the motion to quash is civil, counsel and my firm filed a motion to quash on the 23rd. We filed a declaration of my client and supporting points and authorities. This court issued a minute order sealing those records, and those phone records have not been turned over to the police department or the DA. They're presently under seal before this court. The declaration in question, Your Honor, as seen by the first board, indicates that the materiality is, quote, filed by the DA, necessary to prove the charges filed against the defendant. That statement, Your Honor, does not comply with CCP 1985 or 1985.7. There is no factual showing of materiality. What I'd like to do with the court, there are 3 key cases. We filed extensive points and authorities. I can only comment that the district attorney's office has not filed any points and authorities in opposition to the law on the subject. The first case I'd like to go into, Your Honor, is People versus Schmidt. In the Schmidt case, the defendant was on trial for conspiracy, grand theft, and other matters. The district attorney in that case filed a motion to suppress subpoenas issued by the defense. The court, in affirming the trial court's quashing, indicated, and it's shown here on the first board, Your Honor, quote, the allegations of defendant's affidavits were wholly insufficient to show what material facts, if any, would or could have been proved by the documents sought to be produced. And then the court, on the next page, sustained the quashing of it. The key case, Your Honor, is Johnson versus Superior Court. In Johnson versus Superior Court, the language was, quote, necessary to prove the allegations in the case. And our language is, quote, necessary to prove the allegations of the defendant. The Johnson court said, no good, sustain the quashing. Now, subsequently, in the Pacific Automobile case, Your Honor, the Court of Appeals said that subsequent facts adduced in court are not sufficient basis to be used to support the subpoena deuces taken. Now, what has happened in this case, Your Honor, yesterday morning around 9 o'clock, I received by fax from Ms. Lewis a supplemental declaration alleging some, quote, new facts that they're now trying to use to bootstrap the subpoena that was issued some weeks ago. Under the Pacific Automobile case, that authority does not allow for that, Your Honor. Now, I note, Your Honor, that has the court received the supplemental declaration?
No, I have not.
Oh, Your Honor, I filed that yesterday morning. I'm sorry that it was not given to you.
Not in my notebook of items.
Your Honor, I believe the court would benefit by reading that before.
Let me check with Mrs. Robertson. Mrs. Robertson, do we have the supplemental declaration in support of the SDT? Proceed, counsel.
Your Honor, my concern about the supplemental declaration says in a footnote, we're filing this response under seal to protect the phone numbers in question from being revealed to the public by the press. I want to go into the facts of the supplemental declaration, but I won't refer to the phone numbers. Is that appropriate, Your Honor?
Certainly.
The declaration is approximately 5 pages, and it concerns not only my client, but about 80% of it concerns Mr. Sachs's client. I'll only refer to those paragraphs that relate to my client, Your Honor. The district attorney now, and it's signed by Sherry Lewis yesterday, so this is what they're trying to use to bootstrap the subpoena issued some weeks ago. It says on February 10th, the district attorney's office issued a subpoena DT. And then they say on paragraph number 5, on January 31st, 1995, district attorney's office interviewed a woman by the name of Ziona Friedman. Ms. Friedman is a maid who currently lives in West Hollywood, and I'm leaving out the addresses and phone numbers. It says over the 8-year period prior to the murders in this case, Ms. Friedman was regularly called by the defense maid, Michelle Oberon, to help her at the defendant's Rockingham estate. And then they talk about some work that maid does. On February 8th, 1995, Ziona Friedman was interviewed a second time at the district attorney's office. During that interview, she supplied many additional details of information she says Michelle Oberon, which is my client, Your Honor, told her regarding the 1989 spousal abuse incident between the defendant and Nicole Brown Simpson. And then the only thing left in there regarding to my client is paragraph 8C. Ms. Friedman said she talked with Michelle Oberon by telephone almost every day. One of the things Michelle told her was that Michelle had a lawyer, Tuit Shapiro. Michelle had not called Friedman in a week, the week prior to February 8th. Ms. Friedman was very worried and scared about that since she was accustomed to Michelle calling her every day. Then the only other thing in the declaration relating to my client is, quote, the telephone records of my client are necessary to aid in accessing the credibility of Ms. Friedman by aiding in determining the extent of her contact with those witnesses. What we really have here is a lot to do about nothing in regard to Ms. Friedman. If they want to see who Ms. Friedman talked to, they can look at Ms. Friedman's telephone records, and they do have a subpoena out for that. The subsequent declaration, Your Honor, doesn't have any legal effect in terms of the subpoena that was issued some month ago, and that's the Pacific case. It's also interesting, Your Honor, that the staff of the district attorney's office has not responded to any legal authorities set forth by myself or Mr. Sachs. And what you have to balance here, Your Honor, is my client has a right to privacy of association. Who she calls on her own phone, her friends, and what she does is her own business. She is not a defendant in this case. She is not accused in this case. She's not involved. I would suspect, however, that the DA will probably come in again and try factually something else. The only relevance I could see to any part of this, Your Honor, is Ms. Zia Freeman's phone record. And I would suspect and suggest on behalf of my client that if the court wanted to take those records in camera, look through my client's phone records, and deduct out anything except if Ms. Zia Freeman's phone records appeared there, then the district attorney could have what it wants. Then the court would protect my client's right to freedom of association, and that would be the least obtrusive way to resolve this problem, Your Honor. And unless the court has any suggestions, I would submit that that would be the best approach to protect my client's right and give the government what they want, but not open this up to allowing anybody at any time to look at any phone records. Because based on what they have done here, I suspect the defense could take every prosecution witness and request all their phone records, and the prosecution could take every defense and request their phone records. And that's not what it's supposed to be, Your Honor. I'll submit it, Your Honor. Thank you.
Mr. Sachs?
Morning, Your Honor. Good morning. Yeah. In regards to the situation here, we're really concerned with the citizens' right to privacy. And in dealing with the issue as to why my client objects, as any citizen has a right in California to object to anybody looking at her residential telephone records, is because this legislature in the state of California, when they enacted 2891 of the Public Utilities Code, they made a finding that it was of paramount importance that the residential telephone records of all our citizens in this state are accorded the right to privacy. And only if the government can show by the use of lawful process in a criminal case can they obtain those records. Now, in this situation, Mr. Solomon has alluded to the deficiencies in the declaration in support of the subpoena. And when we look at the language where it says necessary to prove the charges filed against the defendant, the cases we've cited show that there's no factual basis of materiality or good cause that would justify the issuance of the subpoena. And if we use that language and say that justifies the issuance of a subpoena, and that alone would overcome the absolute right to privacy that the legislature has enacted under the Public Utility Code, except when a good showing in a criminal case is made, the court would authorize the seizing of 300 defense witnesses' residential telephone records. And if we took the same affidavit and changed one word and said necessary to disprove the charges filed against the named defendant, the court would be authorizing the seizure of 400 of the prosecution witnesses' residential telephone numbers, which would include Detectives Lang's residential telephone numbers, Mark Furman's, Philip Van Adder's, and Ron Phillips. And I don't think the court would allow the defense on no greater a showing that is shown in this affidavit to seize not only 400 records of prosecution witnesses, but the detectives as well and other police officers involved in the case. Now, in dealing with the right to privacy, what we're talking about in this courtroom are citizen rights. This court so far has been concerned with certain rights of the parties. They've been concerned with the rights of the prosecution to get a fair trial, properly so. The court's concerned with the rights of Mr. Simpson to get due process of law and a fair trial, and properly so. The court's been concerned with the rights of the jurors and the rights of those jurors to have their anonymity and to not be harassed by the press and the public. Nobody has addressed...
Properly so.
And properly so. Nobody's addressed to this point the rights of these witnesses. And what we have in this case is 700 people that are on a list. They're all American citizens. Under the statutes enacted in the state of California, all of these witnesses have a right to privacy, unless there's a showing of good cause to go beyond what the legislature said is a paramount, a right of paramount concern when they pass the legislation. So I'd submit to the court, number one, that we have to look to the fact that witnesses have not been spoken for up until this point under these subpoenas. Now, my client has had 8 subpoenas served on her in regards to this litigation. 3 subpoenas to testify before the grand jury under the guise of the Al Cowlings investigation, but all of the questions that she was asked before the grand jury concern this case itself. Since she went to the grand jury, she's received 3 other subpoenas to testify in this case, one of which she was on call for over 3 months before she was released. She's also received, in addition to those 3 witness subpoenas, 1 other subpoena ducis tecum that required her presence, and these 2 subpoena ducis tecums for telephone records. The one being litigated today, and there was another one that was previously issued in July, but she had no counsel at that point, no opposition was raised. Now, in dealing with the rights of the witnesses and the fact that nobody has spoken as in terms of witnesses' rights, we have a lot of situations arising where there have been comments made in this courtroom and I know the court is trying to be very fair to all concerned, but there's certain things that play out in this courtroom that get televised throughout the country, and it looks a little different to the witnesses that it may look to Your Honor. And I will say one thing about Your Honor, you've been very accommodating, as far as I can see, to all the parties that have appeared before you, to all the people that have come into this courtroom have been accorded nothing but the most utmost respect by this court. And I think you've established a friendly environment for the people coming before Your Honor. But some of the things that happen through the litigants plays out through the public, and the witnesses that are under subpoena see this. And there's been certain comments made. First, back in September, there were comments made about my client and some evidentiary issues in regards to some evidence that may have been destroyed. And under a proffered offer of proof that nobody required, my client sort of had a little character assassination made public. Now, tied in with that, there were other comments made about defense witnesses that the prosecution said, I'll tell you about the defense witnesses. They're felons, they're heroin addicts, they're court-certified pathological liars, and felons. Now, nobody mentioned what witnesses, defense witnesses were being spoken about. But what happens is beyond this courtroom, when the witnesses see it, it has to have a chilling effect on people. Because as far as I can see, anytime a defense witness hears their name mentioned at this point, they should be doing two things: jumping for cover and seeking legal representation. Now, in dealing with that, that gives an overall picture of the chilling effect that can happen when comments are made in the shape of litigation, where in a normal case, nobody would know about it. Your Honor would hear a comment made, the parties here would know about it, a few courtroom hawks that would be sitting in the courtroom would know about it, but it wouldn't go any further. But here, when we have these types of situations concerning witnesses, and why I'm concerned with witness rights is because it does have a detrimental effect on the people that are coming in as citizens to do their civic duty, to take the witness stand and to testify to the best of their ability. And as the public has seen, as the court well knows, some witnesses testify better than others due to one reason or another. So tied in with the history of why I'm concerned with witnesses' rights, and more specifically with the subpoena, my client has every right to have her privacy protected, not only under the First Amendment, but under the statutes we cited in our points and authorities. And unless the government can make a good showing as to why that privacy should be invaded, the privacy should be protected. Now, in dealing with the supplemental declaration, I still don't believe that it makes a factual statement that would satisfy a showing of materiality and good cause. But if the court were going to take a quantum leap and say that you feel it does make a showing that would justify some of the records possibly being turned over, I would concur with what Mr. Solomon suggested in the way of accommodation, that the court in camera look at the records and limit any release of those records, for the sake of argument at this point, to the prosecution, only limited to the two parties that they're talking about, Ms. Friedman and Ron Shipp, and limit it to those two numbers alone, and preserve the right to privacy as far as the other calls are made, because as we showed under the First Amendment, the right to privacy of Ms. Randa, as well as any other citizen, covers their personal contacts with the people they associate with day in and day out. And what more of a personal contact do you make other than face-to-face than when you call somebody from your own residence? Secondly, I'd like to address the issue of the violation of the Consumer Protection Law under 1985.3, where there is a burden placed on the prosecution or any other party seeking to get a subpoena from a consumer record, which the telephone company records are, that due notice has to be given to the consumer. In this case, it's my client, Kathy Randa. The prosecution under 1985.3 subdivision E is required to serve a copy of the subpoena with the declaration on the consumer and give them notice that they have a right to contest the subpoena in court. Now, I would like to state that in regards to the first subpoena issued last July, no notice was given to Ms. Randa, and I filed a supplemental declaration to that effect. She received no notice on the first subpoena. She received no notice on the second subpoena. In addition, the prosecution has known since September the 19th that I have been representing Kathy Randa, and they made no attempt to give me notice by supplying my office with a copy of the subpoena or the declaration. And this was even after I requested from Ms. Clark and Ms. Hodgman by way of fax on both the 18th of February and the 21st of February that my office be provided a copy of the subpoena and the declaration so we could take appropriate action. The only reason I received a copy is I requested the assistants of Mr. Cochran's office, and through their good offices, I did receive a copy. Now, the only reason I knew to ask for a copy of the subpoena wasn't because we received any notice from the prosecution. The only notice we received was from Pacific Bell. And Pacific Bell has a company policy, not required by law, but a policy of their company to notify their consumers and their customers when a subpoena has been served upon the company for those records. If it wasn't for the fact that the telephone company sent my client a letter, this motion would have been heard in silence and secrecy because the court would have had no opposition. The subpoenaed records would have arrived in court, and pursuant to the subpoena, it would have been handed over to the prosecution. So with a total element of secrecy and no notice being given to my client, her privacy would have been invaded in violation of not only the Public Utility Commission law as set forth in Section 2891, but in violation as well of the Code of Civil Procedure Consumer Notice Requirements of 1985.3. Based on two intentional violations of the law, I would request this court issue sanctions at this point, because this is no different than the situation where sanctions have been issued against the defense and the prosecution for failure on both sides to comply with 1054 of the Penal Code. And I think that it sets a standard that the prosecution, if they're going to issue subpoenas, or if the other side's going to issue subpoenas as well, they've got to comply with the law to protect the rights of these witnesses, because these witnesses are American citizens. They're entitled to every protection under the Constitution and every protection under the special statutes that the state of California has passed to deal with this issue. And based on those arguments, I would submit that the subpoena should be quashed, and the alternative sanctions that the court deems appropriate should be issued against the prosecution for the violation of my client's rights to notice under the law and an attempt to invade her privacy without due notice.
All right,
Thank you, Your
Mr. Sachs, let me ask you this. With regards to your request for sanctions, what do you think are appropriate?
Well, my client's, to be quite frank, my client hasn't incurred any legal expenses because, without breaching the confidentiality of the attorney-client privilege. I can just say that my work here is pro bono. But I think some monetary sanctions may be appropriate just as an out-of-pocket expense to the district attorney, but I'm not looking to unjustly enrich myself. But I think in terms of sanctions, the court isn't concerned with dealing with monetary sanctions. I think an admonition to the district attorney's office with further compliance with the requirements under the statutes that I've cited would be appropriate. And I think if any of this evidence comes before the jury, then an appropriate sanction should be assessed against the district attorney, where the jury's informed of the fact that the prosecution in regards to my client's rights, when she's called as a witness, has been infringed upon. And when they cross-examine about telephone records and so forth and so on, I think an appropriate admonition to the jury, informing them that the district attorney acted improperly in trying to seize the witness's records. And I think it's something that I would ask the court to heavily consider, and I don't think it should be taken lightly. And it sets the standard, as this case commences down the line, that the either party issuing subpoena duces tecums that would fall within the purview of this statute or some other right to privacy being invaded is complied with. Because I think all the witnesses should feel as comfortable as possible coming into this courtroom to testify. I said it once before in another forum that the only people that like coming into this courtroom are the people that work here. Your Honor, the attorneys, the court staff, we do this for a living. We're used to what goes on here day in and day out. But the average citizen that's called upon to come through these doors and take that witness stand does have a lot of apprehension because they can see what happened to Rosa Lopez, whether it's good, bad, or indifferent. It was 4 days on the witness stand. Detective Lang's been on the witness stand for a long period of time, but there's a little compensation in his regard. He's more or less a professional witness because with his job, over the years, he does testify on a normal basis. But the average citizen here in America that's called into this courtroom to testify, especially the fact that it's going into every big city, small hamlet, township, and county throughout this great land of ours, knows that whatever they say, not only is everybody seeing what's being said, the public at large, but their friends, associates, the people they work with, and all of the commentators on TV are nitpicking and analyzing to the 10th degree exactly what that witness said, how he said it, or she said it, whether or not she's credible or maybe lying, mistaken, or whatever. And that does have a detrimental effect on these people. So what I'm concerned with, and I think, even though I pointed out, I think the court has been over-accommodating to be as generous and courteous and as courteous to everybody that works in this courtroom and comes in here. There is a chilling effect that these witnesses feel just from the fact that it's abnormal to come in and have to testify. And most people think they're going to get on that witness stand, they're going to be grilled right and left, and they don't know what to expect. But what's happened in this case, when it goes out to the public at large and people see what happens to each witness as they come in, most people, if they had their druthers, would never want to come in and testify. At this case, other cases, you know, you work your nerve up, you go in, you testify, and then you're back to what you normally do. But in this case, with that camera in this courtroom, it has an extreme effect on the witnesses. And I think that when I ask for sanctions, it's not just in terms of my client alone. I'm concerned with the witnesses who have to come forward, whether they're prosecution or defense witnesses. They have certain rights, and I think the court should bend over backwards to protect their rights as well. And I do have to apologize. When I was talking about protecting rights, the victims' rights are properly protected in this case. We have two decedents. The court has every intention to treat those people with dignity and the respect that they're entitled to. I'm just asking for the same thing for my client and the other civilian witnesses that are called upon to do their civic duty and come in here and testify.
All right. Thank you, Mr. Sachs.
You're welcome, Your Honor.
Ms. Lewis? Morning.
Good morning, Your Honor. Thank you. First of all, Your Honor, I think we need to back down a little bit from some of the rhetoric and see what the scope of this particular hearing is. While it's, I think, evident that I agree with protecting the rights of witnesses, particularly given the motions that I've filed and argued regarding Detective Mark Furman and his privacy rights, we are here today to talk about two particular subpoenas that were issued for phone records of two particular persons. Michelle Abduran, who was the defendant's maid for many years over in Rockingham, and Kathy Randa, who was the defendant's administrative assistant for probably 20 years, something like 20 years. Now, what concerns me, Your Honor, is that the court has not yet read the supplemental declaration that I filed. As Your Honor knows, the District Attorney's Office issues thousands of SDTs per month throughout the county for records of all sorts, including phone records. We are aware that it is the custom and practice of Pacific Bell to alert consumers should they have any concern about that. You know, I don't want to go into a lengthy rhetoric myself about the cost currently of the criminal justice system, the difficulties our office has in obtaining appropriate budgeting, especially given the current 3 strikes laws. We do the best we can under the circumstances, Your Honor. Now, because there was concern raised in this case with the privacy of the two particular witnesses involved, I took a look at the declaration which we sent out, which is a pro forma declaration, frankly, that says that they're necessary to prove the charge as the records are. That's something that our office routinely puts on subpoenas, as I'm sure Your Honor is aware. And to take the time in every case and every type of subpoena for records to have to detail the reasons for it would require substantial additional time on the part of DAs handling all these cases for which we issue these thousands of subpoenas. But, Your Honor, because the privacy concerns were raised, I did I set forth in detail the reasons why we indeed subpoenaed these particular records. And the timing is self-evident. We are not trying to manufacture facts later. These records were subpoenaed on February 9th and 10th, and they followed our second interview of Ziona Friedman, which was on February 8th. That lady is also a maid, and she was a maid who Michelle, the defendant's maid for approximately 8 years, called regularly to assist her when the defendant was entertaining. She's also someone, Michelle and Ziona Friedman were close together, and in fact, their records were subpoenaed on the same STT. And Ziona Friedman has not sought legal counsel to move to quash the subpoena for her records. When we interviewed her on February 8th, and this is set forth in more detail in my declaration, she initially, in being driven to the interview, she expressed concerns to one of our DA investigators that she felt she was being pressured and harassed by Ms. Randa to disassociate herself from the prosecution. And she was very adamant about those concerns. When we got to the interview, the taped interview, she denied that, but she still acted very scared, said she was very scared, very concerned. It appeared that she'd wanted to talk to us, but she was terrified of doing so. In addition, she set forth additional information that she had not provided with regard to Michelle's recounting of the 1989 domestic violence incident. If the court recalls, I believe the court heard testimony during trial and or during the representations made during the 1101B hearings that Michelle was the person indeed who tried to pull Nicole Simpson out of the car, out of the police car back in 1989. So, and Michelle as well is someone who had, during the period in time in question, called this other maid, Ziona Friedman, who has been cooperative with the prosecution almost every day, according to Ziona, so that her telephone records would be the one that would show those calls to Ziona rather than vice versa. In addition, the court will recall the testimony of Ron Shipp, where he indicated that he was considered himself a good friend of the defendant and of Kathy Randa, and he alluded to himself and Kathy Randa sharing, mutually supporting each other with regard to drinking problems. It was the allusion there. And because Mr. Shipp did not come forth to the prosecution until January 28th, I believe it was, with revealing the defendant's incriminating statements about having had dreams of killing Nicole Simpson. Because he did not come forth until that date, the phone records of Kathy Randa showing calls during the time in question from November, December, and January, not only to these maids in question, but also to Mr. Shipp, further corroborates his explanation that he was a friend of the defendant's and his bias, his natural bias, was for the defense. And it does corroborate why he did not come forth until late in time in revealing that incriminating statement of the defendant's, which he finally testified, I believe, was because he did not want Nicole's blood on his hands, and his guilty conscience could not stop him any longer. I would certainly ask the court to read the declaration in detail. What we have is a situation here, Your Honor, where let me make mention of one other thing. Ms. Randa was notified with regard to her phone records, which were obtained earlier, by Pacific Bell. It's attached as Exhibit C to Mr. Sachs' supplemental declaration in support of motion to quash Kathy Randa. I'm sorry, in support of motion by Kathy Randa to quash subpoena ducis tecum, and that shows that she was notified. In addition, Your Honor, Mr. Sachs may be unaware, but we did provide the discovery to the defense in this case, who has standing for that those phone records were also obtained pursuant to a search warrant, which covered not only those records, but several others having to do with that period of time of the week during which the defendant was finally arrested on the 17th of June. So she did, but she was notified because we also SDT'd them. She was notified by Pacific Bell about those. We are here at a point in time, Your Honor, where these witnesses have had notice now. Have started to say hired, but I guess not hired. They do have attorneys. They have attorneys who have filed points and authorities on their behalf. The court, I believe, has the records before it. The court, we're in a situation where the court is able to make a judicial determination based on the additional facts I set forth in our supplemental declaration, and that is all that should be required at this point in time. We certainly don't want to unduly harass either of these witnesses by resubpoenaing the documents just so I can set forth my 4 or 5 page declaration within the context of our standard SDT format. I also wanted to mention a couple of cases that it's actually one case by the California Supreme Court, Associated Brewers Distributing Company versus Superior Court, a 1967 case at 65 Cal 2nd, 583 at 587, and a case which quotes that case and invokes its holding, People versus Bigelow, BIGELOW, a 1988 case at 200 Cal App 3rd, 59 at page 61. Both of those cases talk about when the subpoena power is invoked to secure discovery, the good cause and materiality requirements of Code of Civil Procedure, Section 1985, which relates to the issuance of subpoenas, must be governed by discovery standards. And they also say, quote, the objective is not merely the discovery of admissible evidence, but also effective preparation for trial. So when the court reviews the supplemental declaration, which I filed, I would ask the court to, I would remind the court that even though we're in the middle of trial and the court is deciding the admissibility of evidence, the standard on discovery is whether the records sought will tend to lead to admissible evidence or would enhance the effective or allow for the effective preparation for trial. So, Your Honor, while Mr. Sachs talks about the rights of 300 witnesses or so forth, we had good reason to subpoena these particular records in question, and I set forth those reasons, which were not after discovered facts, but facts that happened right before the time we subpoenaed them, and that's why we subpoenaed them. I did all that to allow the court to make an intelligent decision as to whether there indeed is materiality shown. And in addition, I don't think I mentioned in the declaration, but of course these records are not available from any other source, and that's always one of the reasons given why records are necessary from a particular source. So I would want that in the record as well. Of course, these phone records are not available from any other source that we're aware of.
Ms. Lewis, do you have any comments regarding the request for sanctions and whether or not the policy of Pacific Bell to notify their customers is really sufficient compliance with the public utility codes?
I believe it is sufficient compliance, Your Honor. I would not want Your Honor to set precedent that would require, I don't know how much money, but substantial additional money expended by the budget allotted to the district attorney's office from the Board of Supervisors, which comes from the taxpayers. Because if we were required to notify the consumer in every case, that would substantially increase the expense to the district attorney's office of having to do so, and especially given our knowledge that it is Pacific Bell's custom and practice to submit, whenever they return a subpoena, their points and authorities and their notification, with the records.
What's the policy of the General Telephone?
Well, my understanding is the policy of all the phone companies is the same, but I have to tell you, I haven't called GTE in particular and asked them that.
All right. Mr. Solomon, any response?
A couple,
I'm sorry. Let me ask Ms. Lewis one more question. Ms. Lewis, both Mr. Solomon and Mr. Sachs have suggested that, assuming the worst-case scenario, that I find that there is some materiality and that rather than require you to reissue a subpoena with a 5-page declaration in support, that they're recommending that the court review the phone records in camera and redact those records just to reflect the phone calls between the persons that you've indicated are material, rather than allowing the prosecution unfettered access to the complete phone records of Ms. Randa and Ms. Abdurrahman.
I think that would be appropriate, Your Honor. With regard to Ms. Randa, I think, as the court will see from the declaration, there are other persons which would be relevant. For example, Ziona Friedman was advised by Kathy Randa, I believe, I've set it forth in detail in my declaration, to call Bill Pavlik. She said, something to the effect of, my God, please, for OJ, call Bill Pavlik before you talk to the prosecution. We didn't find this out until the second interview we did of her on February 8th. And she said she did call Bill Pavlik, indeed. And she claims that Mr. Pavlik told her only to tell the truth. Well, I think the length of a phone conversation between those two would be useful in assessing the accuracy of that statement. So, and she also indicated that she called A.C. Cowlings.
All right. Ms. Lewis, forgive me for interrupting you, but the question, my specific question, though, is that would you accept that, a redacted phone record rather than the complete phone record that you subpoenaed?
Yes, Your Honor. And we would just need to make the court specifically aware of the phone numbers that we are interested in.
All right. Thank you. Mr. Solomon.
yes, Your Honor. I've never heard of the largest, public law firm in America saying that they don't have the time, effort, ability or staff to fill out a subpoena dues are taken appropriately. If in the civil court I had done what the district attorney had used and come in and said, well, we don't have the staff to do it, they'd be looking for me to do another job, Your Honor. You can't delegate the functions of subpoena DTs to one line. You've got to use the appropriate language to protect people. Now, I'm not worried about the rest of the world. I'm worried about my client. That's all I represent here. Now, I've heard no justification other than this is the way we've done it for years. Well, the consumer notice requirement, they don't even give. 1985.3 is mandatory, not on the telephone company, but on the government who was ever attempting to issue the subpoena. I've heard no justification for the court not to impose sanctions. And the question you asked, Mr. Sachs, is what kind of sanctions to impose. Well, first of all, it should be payable to the court. Not to cancel. And second of all, it should be appropriate with any other type of sanctions that this court has given in the past, either against the prosecution or the defense, and whether or not you admonish the jury is something that's not really an issue, I think. I think it should be a financial sanction to impose upon both the prosecution and anybody else who appears in this court that if they're going to subpoena records of people, you better comply with the law. I would also comment that the comments made by Ms. Lewis regarding who said what to where, et cetera, is all hearsay declaration by Ms. Lewis. There is no declaration in this court, in this case, for these subpoenas by any of the investigators or by Ms. Clark, who was in the interview. It's by Ms. Lewis, who heard it from X, Y, and Z. So we have a trail of hearsay here. And also in regard to my client, they're not asking for records when she was there, Your Honor. They're asking for records from November 1st through February 10th, some 4.5 months after the incidents. In spite of all that, we'll still go along with a redacted version to save us from coming back here again. But I think, as Mr. Sachs indicated, it is appropriate in this case to sanction the prosecution. Thank you, Your Honor.
Thank you, counsel. Mr. Sachs, any brief response?
Yes, Your Honor. In response to the declaration itself and what we've heard is hearsay on hearsay, we're not here to litigate the truthfulness of that declaration. It's just whether or not that declaration would suffice as good cause. My client categorically denies any allegations of wrongdoing made against her in that declaration. But in dealing with the position of the district attorney's office, my law office doesn't have a $125 or $150 million a year budget. And yet I find time to draft a declaration in support of a subpoena ducis tecum as an attorney practicing by himself. I can't understand why attorneys claim that they don't have the money when all it does is take time and effort to properly draft a document. I think the court, if they want to brief on something, you expect an issue to be fully briefed by both sides and not to get sloppy lawyering in the process. Now, in addition to the sanctions situation, I think Ms. Lewis missed the point. She's telling this court that sanctions shouldn't be imposed because of the policy, the company policy of Pacific Bell. My client did get notice. Well, my client got notice that there was a subpoena, but she never got the subpoena. And it's not the requirement under the law for the Pacific Telephone Company to give notice to their subscribers. They do that as a courtesy, but if they stop that courtesy tomorrow, who even gets any notice that they're holding a subpoena for those records? 1985.3E of the Code of Civil Procedure requires on the government or any other party seeking a subpoena under these circumstances to give direct notice. God bless you. Give direct notice to the consumer or their attorney. The district attorney didn't stand before this court and say, in the future, we're going to give notice to the witnesses. She said, we're going to rely on Pacific Bell to continue with the company policy. And that's not what the law requires. And I think that emphasizes the reason why the court should seriously consider the requested sanctions being imposed at this time, because they're not going to change their ways. They're not going to change their minds. They're just going to continue to do things in the same way that they think is appropriate, which amounts to nothing more than governmental abuse against a citizen of this state that's protected under the law to receive the notice that the law says they should get. And to do otherwise is a violation of the law. And to stand before this court and say we're going to continue to do the same old thing because we don't have a 32-cent stamp to send out the subpoena to Ms. Randa or her attorney is the basis of which they're stating they're going to continue to not comply with the law. And I find that ludicrous that the price of a 32-cent stamp and the cost of Xeroxing 2 pieces of paper, which is the subpoena and the declaration to support, is the basis to intentionally continue to violate this law. And I'd submit it on that basis.
All right. Thank you, counsel. I'm going to take the matter under submission so I can read the declaration filed by Ms. Lewis, and I will issue a written ruling. All right, thank you, counsel.
Yeah, just for the record, I read the transcript of the interview with Zayona Friedman, and I listened to the other taped interviews, so it's not hearsay upon hearsay upon hearsay.
Thank you. Record should also reflect that it's GTE that responded, not Pacific Bell. All right, I'm going to need to take a brief recess. We have the custodian of records here from the LAPD that I need to chat with on the record in chambers. So we'll take about a 15-minute recess. Our jury panel. Ladies and gentlemen, good morning. My apologies to you for the delay this morning. We've been in session since 9 o'clock. I had two matters that I had to deal with regarding the production of evidence by third parties, so I had to rule on those motions before we could start today. All right, let the record reflect that Detective Tom Lang is still on the witness stand. Good morning again, Detective Lang.
Morning, Adam.
He is on redirect examination by the people. Ms. Clark, you may continue.
Good morning. Detective Lang, you were speaking yesterday of your reasons as to why, in your opinion, based on what you saw in the course of your investigation, you did not believe these to be drug-related murders. You recall that?
Yes.
In that regard, sir, do you recall indicating to Mr. Cochran that there were superficial inquiries made concerning the topic of whether or not drugs were involved in these murders? Do you recall that?
Yes.
Can you please explain to us what you mean by superficial inquiry?
Checking the location for drug debris or drug paraphernalia, for weapons perhaps, for anything that would indicate narcotics activity on the part of the victim or the suspects.
And so was that an examination that you made at the crime scene?
Yes.
And was the condominium, was Miss Brown's condominium examined by police?
Yes.
Were there any drugs found?
No.
Were there any paraphernalia for drugs found?
No.
Any scales or anything like that?
No.
Any paraphernalia for the usage of cocaine
No.
or marijuana?
No.
Did you find any writings in the way of pay-and-o sheets concerning monies to be paid for a kilo of this or a gram of that?
I did not.
Was any material like that ever found in the apartment, the condominium that was shown to you later?
No.
Was Mr. Goldman's apartment examined also?
Yes.
And was anything related to drugs or drug paraphernalia found in his apartment?
Not to my knowledge.
And would it have been brought to your knowledge, sir, as the lead investigator?
Calls for a conclusion.
Was the evidence was the apartment, the findings made in the apartment of Ron Goldman made known to you, sir?
Yes.
And was anything made known to you concerning the search of his apartment?
Complete the question.
Let me start another one, if you're on. Were any drugs or drug paraphernalia seized from Mr. Goldman's apartment, sir?
This is my personal knowledge of this specific car location.
This is the basis of his opinion.
All right. Ladies and gentlemen, this information is limited only to the state of mind of this detective. It's not necessarily true. It's his state of mind.
Thank you.
Ms. Clark.
Not to my knowledge.
Other detectives searched Mr. Goldman's apartment, is that correct?
Yes.
Was that at your direction, sir?
Yes.
Did they turn over to you any evidence of drugs or drug paraphernalia found in Mr. Goldman's apartment?
No.
Was there any pay-and-o sheets indicating monies paid or received for the sale of drugs?
No.
Were there any scales or cutting agents or debris associated with drug usage or drug sales found in Mr. Goldman's apartment?
No.
And is that, did you complete your answer with respect to what you meant by the superficial inquiry? Is that what you meant?
Sustain.
Did you have anything further to add? I don't know if I cut you off, sir.
No, that's it.
Now, with respect to, you also alluded to yesterday, the manner of killing as another reason why you felt these were not drug-related murders. Do you recall that, sir?
Yes.
You referred to the fact that
This is improper calculation.
Oral foundation.
you
the
referred
next
to the
question,
fact
I
that,
assume.
in your experience, it's usually firearms, guns that are used in drug-related murders.
It's been my experience, yes.
Was there anything about the nature of the wounds that you observed, either at the crime scene and in the course of the autopsy, that caused you to conclude that these were not drug-related murders?
Yes.
And what was that?
This appeared to me to be an overkill or a rage killing.
And how is that different than what you see in drug-related murders?
Object to that.
Oral. Oral.
Again, in my mind, it appeared to be motivated by rage and not narcotics related.
In narcotics-related cases, what kind of wounding do you typically see
Object.
as compared to this case?
Oral.
Generally, you would see a gunshot wound is what I saw normally.
I'm sorry?
Normally a gunshot wound. The murders that I have handled are normally by gunshot wounds as opposed to excessive slashing and stabbing of the victim.
All right, I believe that on cross-examination also you discussed with Mr. Cochran the possible order of death, whether Nicole was killed first, whether Ron Goldman was killed first. Do you recall that?
Partially, I don't recall testifying to an order of death.
And what is your opinion in that regard, sir?
As to who was attacked or died first,
Yes.
from the evidence, I really can't tell.
Could be either one.
Could be either one.
Yeah, just how my desk leaving the court to reopen direct for the purpose of showing the jury a videotape.
All right. Proceed. Let me just instruct the jury what that means. Ladies and gentlemen, reopening direct means that the prosecution is going to go into something that they did not present previously in their first examination of Mr. Lang, Detective Lang, and I've allowed them to do that rather than to recall the witness at a later time, since he's here. Ms. Clark? It's plain. Do you want that plain? All right.
Sir, I'm showing you a photograph that's been previously marked as People's 57. Do you recognize the location shown there?
Yes, it appears to be the walkway at 875 Bundy, the crime scene.
Can you tell by what you see in that photograph who that officer is?
No.
I'm going to put that up on the Elmo. Or let me also show you Defense 1011. Can you tell us, does that appear to be a copy of the same photograph but with the logo American Journal blocked out?
Yes.
What is?
All right, Ms. Clark, you have on the Elmo which of the exhibits?
This is People's 57, Your Honor.
All right.
All right, sir. Now, can you tell us at what time the crime scene in this case at 875 South Bundy was broken down?
Well, it was approximately 3 or 3:30 that afternoon of the 13th.
Okay. You don't presently recall exactly?
Exactly? No.
Would it refresh your memory if you looked at the chronologue?
Yes.
Go ahead.
Last entry shows 3:45 p.m.
Now, after the crime scene tape is taken down, what is the significance of that? What does that mean?
That the crime scene in effect has been broken down and that the investigators and the officers involved are leaving at that time.
Okay. And does that then permit people to walk inside where the crime scene, the area where the crime scene tape had been previously blocking off?
Well, there'd be nothing to prevent that.
Is there anything improper at that time for police officers then to walk inside the area that had previously been blocked off by the crime scene tape?
No.
Can you tell by looking at this photograph, sir, whether the crime scene tape has been removed or not?
No.
Did you see an officer stroll up the walkway in the manner shown in this photograph during the time the crime scene tape was still up at
No.
875 South Bundy?
No.
The following videotape, I'd ask you mark Peoples next in order, Peoples 101.
101.
Previous.
Can you tell us what's happening here in this portion of the tape, sir?
Yes, the officer is removing the crime scene tape, and the scene is apparently being broken down.
And you said that was approximately 3:45?
Yes.
Then at this point, the crime scene tape has been removed.
Yes.
Does that mean that the investigation has basically been completed in this area?
It's leading.
So, what does that mean with respect to whether or not the crime scene investigation, or the status of the crime scene investigation in this area?
That is it.
Overruled.
At this particular time, it's been concluded.
And stop. I'm going to show you again People's 57 and the defense 1011 and ask you if these appear to be a still frame taken from the video we're now looking at that's been marked People's 101.
Does appear to be a still of that video, yes.
May I ask permission of the court to let the jury, to pass these pictures to the jury while this is still on the screen?
Yes.
Right, sir, and at the time then...
Wait.
Oh, I'm sorry.
All right, the record should reflect that each of the jurors has taken the opportunity to compare People's 57 Defense 1011 with the still frame video that is now on the screen. Ms. Clark, I would suggest we print this out.
Thank you, Your Honor. Then at the time that you see the officer on the walkway as depicted in the photographs and in the video from which the photographs were taken, the crime scene tape, is it up or down?
It's down.
And what is the significance of that, sir?
No,
What does that mean?
that the crime scene investigation at that time has been concluded.
And what does that mean with respect to whether it was appropriate or not for the officer to be on that walkway, walking in the manner you see him in the video and on that still?
It would be appropriate for him to do that.
Can you tell us, sir, in the course of your investigation in this case, approximately how many witnesses have been interviewed?
I'm aware of, I believe, 170 formal interviews that are written. There are several other interviews that are taped. There's in excess of 440 clues, I believe, with numerous interviews associated with each one.
Each of those clues has been investigated, sir?
That's correct.
Total.
And were all of those clues with respect to, were all clues followed up?
We get clues in almost on a daily basis, and it's an ongoing process. But they are all being followed up or have been.
And did you follow up clues that, excuse me, strike that. May I have a moment? And has the investigation of this case, the investigation of this case stopped, sir?
No, it's ongoing.
Is that unusual?
No, not at all.
Can you explain that, please?
In most of my cases, we get information all the time from different sources. Certainly in this case, due to the great amount of publicity, we're getting information on a daily basis and attempting to follow up on all of it.
Well, sir, but in your other cases, has your investigation stopped at the moment of trial?
No.
For how long? For how long does your investigation continue in your other cases, not just this one?
continues right into trial and right through trial.
Is that a typical thing?
Yes, it is.
And do you continue to follow up all leads in all cases that you investigate, that you handle?
Yes.
Your Honor, I have here the printout still from the videotape marked Peoples 101. Ask that this be 101A.
All right, 101A.
In that respect, sir, is this case any different than the other cases you've handled?
Oh,
Just as to the volume of information coming in.
Mr. Cochran?
Morning, ladies and gentlemen. Good morning, Detective Lang.
Morning, sir.
Prior to your undergoing redirect examination, you had a number of conversations with Ms. Clark, isn't that correct?
Yes.
Regarding your testimony and the questions she would ask you?
Yes.
And you discussed and went over the content of the questions and answers that would be posed to you, isn't that correct?
That's correct.
So that you knew what questions she was going to ask, and in fact, that you rehearsed what you were going to be testifying about, isn't that correct? Well,
Rephrase the question.
well, you discussed what you were going to be talking about here in court yesterday and today, isn't that correct?
That's correct.
All right. And in the course of that, when did you do that? When did you have that conversation?
I believe there were more than one conversation.
All right, we'll start at the first one. Let's take when the first one was that you had this conversation with Ms. Clark, preparing you for your redirect examination.
For redirect?
Yes.
I don't recall. Perhaps last week?
Last week, while we were off on this case, that you had occasion to talk to Ms. Clark during that time frame?
I believe it was last week.
Well, counsel, we weren't off from this case just
Well,
last week.
When we were off, when the jury wasn't here.
The jury
All
was.
right, that's right. I put it, we were working, yes, Your Honor, so stipulated. When the jury was not here with us last week, you had occasion to talk to Ms. Clark about your upcoming testimony, is that correct?
Yes.
And where did that first conversation take place?
I believe it was here in the building.
And was anybody else present during that conversation?
I don't believe so.
Now, just the two of you were talking?
Well, there are people that are constantly moving in and out of her office.
Well, the primary conversation was between you and she, is that correct, sir?
Well, there were one or two conversations that I recall that we had in regards to redirect. It's primarily the two of us, yes.
All right, and that took place, as best you can recall, last week up in Ms. Clark's office, is that correct, sir?
Yeah, I believe so.
All right, what date was the first conversation?
I don't know.
What date was the second conversation?
I don't recall what date. It was some day last week.
One day last week.
I believe it was last week.
And did you talk about your testimony yesterday before you took the stand for redirect examination?
I don't believe so.
Did you talk about it today, this morning, before we started, on this part of the case?
There was some conversation, yes.
And that, again, was between you and Ms. Clark, is that correct?
Yes.
Now, with regard to this video that we just saw, I want to have that video replayed if I can, Your Honor. All right. Have that replayed?
People's 101.
Yes. You have shared before it's being put up. You shared with us that
the best of your recollections, the scene was broken down on June 13th, perhaps at about 3:45 in the afternoon. Is that correct?
Approximately, yes.
So, as we know, police officers were free to walk in and out at that point. Hold up, please. Police officers were free to walk in and out of the scene at that point. Is that correct?
Yes.
Now, we also know that, according to your testimony, there were some alleged blood spots on the rear gate of this premises. Is that correct?
That's correct.
And no photographs were taken of those blood spots on June 13th. Isn't that correct?
That's correct.
And nobody even bothered to come back, and you didn't go back and even check until July 3rd, some 3 weeks later. Isn't that right?
The rear gate area,
Yes.
that's correct.
And that scene had been broken down all of that time. Isn't that correct?
That's correct.
In fact, you came back on at least 2 or 3 occasions between June 13th and July 3rd, and you never went back to the rear. Is that correct? No, no, that's good.
Yes.
Is that correct?
Yes.
All right. Now, let us see that video if we can. Ms. Clark showed you this video last week when you were meeting and talking about your redirect examination?
I don't believe I've ever seen this video.
It's very dark. Let me back it up, Your Honor. Can you back up for you? All right. Now, let's stop it there. That white blanket or sheet, was that a blanket or sheet that had been placed over Miss Nicole Simpson's body?
It appears to be, yes.
And when you arrived at the scene, after you got the call and you, from robbery homicide, took over this case, when you first arrived there, was the blood in and around Miss Nicole Brown Simpson's body still wet?
There were parts that I would term around here on the pavement sticky.
All right, and that blanket or sheet there was placed over her body at some point?
Yes.
And do you see the red portions on that blanket or sheet, which is white,
Yes.
that appear to you to be blood?
Yes.
And that blanket or sheet had been on top of her body at some point?
Earlier in the day, yes.
Is that correct?
Yes.
And you never saved that blanket or sheet, did you?
No.
Do you know whether or not there's trace evidence on that blanket or sheet?
Trace evidence?
Trace evidence from her body.
I would have no way of knowing what was on that blanket.
And you never saved it. Was it ultimately thrown away?
I believe so.
Now, you're not a criminalist, are you?
That's correct.
And you're not a doctor, are you?
No.
All right, let's continue on with the video. When's the last time you saw this sheet with the blood there on her blanket?
Morning of the 13th.
And do you know whatever happened to it?
No, I don't.
Did you ever come back to the scene on June 13th after you left about 12 noon?
I don't believe I returned that day.
All right, so if this video took place at 3:45 or thereabouts, you weren't even there, were you, at that point?
I don't know what time the video took place.
Well, you just told us that the scene was broken down at 3:45, so I
Correct.
presume that the first part of the video started at 3:45. Is that a fair statement?
This particular appears to me to be a cutaway, so I don't know exactly what time. The log indicates it was broken at 3:45.
All right, well, when Ms.
This is
Clark...
obviously sometime after that.
All right, but we saw an officer taking the yellow tape down. You recall that?
That's correct.
All right. So you have any problem with that having been close to 3:45?
Again, approximately 3:45.
And you never saw any of this, did you? What's depicted in the video?
I wasn't there.
All right. Now, with regard to officers and their feet and blood, I want to show you a photograph. You step down. Put this over. Question, Mr. Step down here.
Yes.
With regard to, and Your Honor, for the record, we're looking at, plan is 54, this is 54-2. 54-2 photograph. I want you to look at 54-2 here and make sure all the jurors can see it. You see this red substance kind of in the grout ways there of the tile there? You see that?
Yes.
And you see this shoe? I think it's a black shoe, appears to be a black man's shoe.
Yes, we do.
And similar to the shoe you have on there, isn't it?
Certainly is.
And we won't, well, have any photographs of those shoes, but that looks like that shoe, does it not?
Appears to be the same type of shoe, yes.
All right. And do you see where that, it appears to be a right shoe, doesn't it? You see, it appears to be a right shoe, does it not?
I can't tell from that angle.
All right, Detective, can you keep your voice up before?
I can't tell from the angle that I left or right.
Okay, you can't tell whether it's a right or left shoe?
No.
It's one of the shoes, is it not? It's right or left, isn't it?
Yes.
And judging from where that is, if that was a left shoe, where would the person be standing?
Probably off to the right here, at the gate.
All right? But
Or they could be standing at an angle to the side.
all right? But you can't tell us that, can you?
No?
All right. But you can tell us that that shoe is standing right on top of the blood there in that grouting. You see that?
No, it appears to me that it could either be up on the toe or perhaps the arch.
You're telling what? You're telling this jury that this shoe, this particular shoe, the person is on his arch?
I'm not telling you, I'm saying I don't know.
All right.
We could be on the toe or it could be over the arch from that angle. For me, it's a little hard to tell.
All right. Well, I understand the jury has to make a final decision, but look at that photograph, sir. Take a moment and look at it.
I have.
All right. Does that look as though the front of that shoe, the every portion you can see on that shoe, is flat against the tile, sir? Isn't that correct?
I can't tell.
You can't tell that?
Not from that angle.
Would you agree that there's blood underneath where that shoe is?
It appears to be blood in the grouting underneath the shoe, but as far as the shoe goes, whether it's underneath the arch or that person is up on their toe, I don't know.
Well, when you walked around the scene, did you walk around on your tippy toes that day?
At times where I was on my toes, that's exactly correct.
And is this you here?
It may
Is that your
well
shoe?
be.
All right.
And I had no blood in my shoes.
All right. But with regard to this particular shoe, you can't tell whether that's you or Furman, can you?
No.
Or any other detective, can you?
I don't know who it is.
All right. And you agree with me, the picture, this photograph will speak for itself. Is that correct?
Objection, if I remember.
Sustained.
Well,
Pause for two.
all right, Judge. At any rate, so that we're clear, looking at 54-2, you cannot tell us whether or not that's your shoe. Is that right?
That's correct.
All right. And you will agree, however, that the shoe is on the grouting, and under that grouting, there's blood. Is that correct?
No.
There's not.
I cannot agree with you that the shoe is on the grouting if that particular person is up on their front toes or if the grouting is beneath the archway of the shoe. Can't tell you.
All right.
I can't tell from that angle.
But there is blood on the grouting. Is that correct?
It appears to be. That's correct.
That appears to be? Can you look at that
Appears to
again?
be blood. That's correct.
All right. And you were out there that morning. You know there was blood in the grouting, don't you?
Right.
All right. John, I'd like to move this photograph down to the other end so the other jurors can see it also.
Certainly. Mr. Douglas, you want to help us? Photographers are directed not to attempt to photograph this exhibit. Mr. Douglas, could you turn the board around, please? Thank you. Thank you, sir.
That photograph that we were just referring to, number 54-2, was that taken at Mark Furman's direction, if you know?
I don't know.
Was that photograph taken at your direction?
Very possibly.
What do you recall?
That specific photograph, no.
You don't recall who directed that photograph to be taken?
Again, I do not recall who directed that specific photograph to be taken.
Do you know whether or not you were at the scene when that photograph was taken?
I can't say whether I was or not.
All right. Now, Detective Lang, with regard to the tennis shoes, and you recall the video where you were shown carrying the tennis shoes under your arms, remember that?
Yes.
And were you trained to do that in the academy in case there's trace evidence on items such as that to carry it under your arms like that?
I don't really understand that question.
Okay, let me see if I can ask it another way. When we saw you in the video carrying the tennis shoes under your arm, do you recall that?
Yes.
All right, would you like to see it again? Is that a fresh recollection?
I recall the video. I don't need to see it again.
All right. And the way you were carrying the tennis shoes in the video, were you seeking at that time to protect trace evidence, which may or may not have been on those particular shoes?
Trace evidence may or may not have been a consideration. The reason that I obtained those shoes was to have red stains checked for the possibility of blood and to obtain a shoe size.
We understand that, and we know it was negative for blood, right?
That's correct.
All right. The question was about trace evidence, sir. And
Trace evidence, sir, was not foremost on my mind.
All right, well, I understand that, but you're the investigator, and I understand it may have been foremost on your mind. But if there were trace evidence on those particular tennis shoes, wouldn't that be valuable evidence either to exonerate or to inculpate Mr. Simpson? Isn't that correct?
I think that's argumentative, but it's possible. And maybe
since,
not. I really couldn't say.
Since nobody's objecting, why don't you just try to answer it? Question.
That's my answer.
All right. That you don't think the trace evidence would have been relevant in this instance?
No, I said it could be, and maybe it couldn't be.
In the course of your discussions with Ms. Clark, did she tell you that you need to be more aggressive in your answers at some point? Because I was making points in cross-examination. Did she tell you that?
Aggressive?
Yes, be more aggressive in your
I
responses.
don't recall her instructing me to be more aggressive.
What word did she use?
I don't recall any word that she used.
Did Mr. Darden use the word be more aggressive?
I don't recall Mr. Darden telling me to be more aggressive.
All right. At any rate, you weren't concerned about trace evidence as you carried these tennis shoes under your arms. Is that correct?
Trace evidence was not foremost in my mind under those circumstances.
The question was, sir, please answer the question. Were you concerned about trace evidence when you carried those tennis shoes under your arm? Oh,
Trace evidence was not foremost in my mind at that time.
that's not my question. The question was, were you concerned about trace evidence?
It was not foremost in my mind.
Well, if there were blood on those tennis shoes and you carried it under your arms, wasn't there a chance you might wipe that blood off?
Not from the stains that I observed. They were on the top of the shoe, on the side of the shoe. They appeared to be dry. Those shoes had been sitting in that closet on the floor. They'd been in other places other than the crime scene. Trace evidence, because of that reason, was not foremost in my mind.
All right, well, let's look at the video.
I obtained those shoes to obtain a shoe size and to check for the presence of blood.
You've told us that, and we know it was negative for blood. Can we see the video? I want to ask some questions about it.
Yeah, Mr. Cochran, which defense exhibit is this?
Your Honor, let me check.
Okay.
1049, I'm advised, Your Honor. Thank you.
All right, thank you.
Now, stop it there. Well, you see how you're carrying the tennis shoes at that point?
Yes.
And at that point, I know trace evidence wasn't uppermost in your mind because you have the shoes against your body there, don't you?
They're against my arm, yes.
Yes, and is that a way that you, as an experienced investigator of over 20 years, learned to carry evidence?
That's one way of carrying evidence, yes.
And you learned to carry it that way, did you, at the academy?
There's no one way to learn to carry evidence.
All right, but certainly you carried it on this way on this date, is that right?
That's correct.
All right, continue on.
Hold on.
You can print that out, young.
Do you want to print that out
Yes.
because the,
Yes, it's part of 1049, and we'll
Yes.
perhaps make this 1049A.
Yes.
Print that out. Yes. Thank you. Is that your clipboard that you have those shoes on?
Yes.
That's not a box, is it?
Boxes in the trunk.
It's not a box, is it?
That's a clipboard.
All right. I thought so. Thank you, Mr. Harris. Now, I think we already established that those tennis shoes were then taken by you to the lab the next morning on June 14th, right?
Yes, sir.
Now, you've testified that you saw criminalist Fung at the Rockingham location sometime after 5:20 on the afternoon of June 13th. Is that correct?
I don't recall the time.
Well, what time do you think it was? that you saw him?
I believe I arrived approximately at that time. I don't recall what time I might have seen him.
It was sometime after 5:20. Would that be a fair statement?
I can't say.
Well, you saw him after you got there, didn't you?
I believe I did.
All right. And at that time, did it ever occur to you at any time before you left to get in your car to go home to give those tennis shoes to Mr. Fung, since ultimately they had to go to the lab anyway?
I believe Mr. Fung had left by the time that I retrieved those tennis shoes.
The question was, did it ever occur to you to give those tennis shoes to Mr. Fung? That's the question.
If he's not there, I couldn't have given them to him, so no, I wouldn't have.
The fact that you could have recovered the shoes and stayed around, he may have been there earlier. So I'm not arguing with you. I'm just asking, did it ever occur to you to give those tennis shoes to Mr. Fung, or for that matter, any other criminalist who may have been at that scene?
Mr. Fung was not there when the shoes were recovered, so it certainly did not occur to me.
What time were the shoes recovered?
I believe it was sometime after 6 or 6:15.
Do you have a record that indicates that?
The time of recovery?
Of the recovery of those shoes. Can you look in your notes and tell us that?
No.
You're speaking from your own independent recollection?
Speaking from my recollection, and I don't recall seeing Mr. Fung at that location at that time that I came down and left.
Do you know what time Mr. Fung left that evening?
No.
Have you seen a log which would indicate what time he left?
No.
Do you have such a log?
Do I have a
Yes,
log?
as to what he left.
I don't believe I do.
In your books there, do you have the criminalist log, which would indicate what time Fung left on June 13th from the Rockingham location?
I don't have a criminalist log.
All right. Do you have a log which indicates what time you left?
I don't know if there was a log that was taken at that time or not.
Can you take a look? Can you take a look for us and tell us whether you have that?
Yes, it's right in front of me.
May I approach that?
Yes.
First of all, does that log indicate what time you recovered these tennis shoes?
No, it wouldn't indicate a time of recovery.
All right.
May I see counsel at the sidebar without the report, please?
So
Thank you, counsel. Proceed.
the log before you, what time does that show that you arrived back at the location of Rockingham? It's 17:15?
Shows that I arrived at 5:15, yes.
All right, 5:15. And as far as you know, Fung was still there at least until 5:20, isn't that correct?
I don't recall.
When you...
One view, microphone.
Sorry, dear. Use your microphone.
Again, I don't recall.
Did you ever see Van Adder give criminalist Fung Mr. Simpson's blood that was contained in a vial that had been taken downtown here at Parker Center, out at Rockingham at about 5:20 or thereabouts on the evening of June 13th, 1994?
I didn't actually see him do that, no.
You never saw it? You weren't present when that happened, or if it happened?
I don't recall seeing it. I don't recall seeing it happen visually.
All right. So, at any rate, what time does it show you leaving the Rockingham scene?
At 7:10 p.m.
All right, and that refreshes your recollection, that's about the time that you left?
Yes.
And at that time, you don't know, or do you know whether or not Fung had already left at that point?
No, I don't recall seeing him.
All right. Did you talk to Mr. Fung at all while you were at the Rockingham location that afternoon after you came back at 5:15, if you recall?
I may have had conversation with him.
And where would that conversation have taken place?
Probably in the house, upstairs in the master bath area.
Now, you and I had some discussions regarding a green piece of paper inside a bag that contained Mr. Goldman's clothes. Do you recall that?
Yes.
Hold on, let me toss the Goldman.
All right.
Mr. Cochran?
Thank you. And prior to my asking you questions about that green piece of paper, had you ever seen that before?
No.
And did you not tell us that the items in that green paper bag were recovered by Officers Tippin and Carr? You tell us that, Mr. Goldman's residence?
I don't recall if I did. If I did tell you that, then I misspoke.
Well, maybe I can read it to you. That if you said that, if you said the clothes were... Yes.
The day before yesterday.
He has it on his computer, and I think I can get it on his computer.
We all have it on our computer. I don't think it's on the note yet.
This is from his computer. Let me ask you this question.
Well, I'm going to overrule the objection at this
Thank you.
point.
Do you recall being asked, this is the day before yesterday, this question by me and giving this response? Question at line 26. How were these clothes recovered, and what is the connection of the bag with the clothes? Answer, once again, they were recovered by detectives Tippin and Carr. You remember so testifying?
I may have.
And you went on to say, I wasn't there, I couldn't answer that question, but it was booked in the Vaughn's Pavilion bag along with this envelope. Is that correct? Answer, apparently. Remember so testifying?
Apparently.
All right, now, is that what happened?
No. Pardon?
Is that what happened?
No, those clothes were recovered by the Goldman family.
So you want to change your testimony under oath?
If I stated that, then I misspoke.
You misspoke?
That's correct.
So Tippin and Carr didn't recover them?
Did not. The clothing was recovered by the Goldman family.
And when you were testifying the other day, when you were under oath, you were trying to be as accurate as you could, were you not?
I always try to be as accurate as I can.
I'm not what you always do. The other day when you
The
testified.
other day, today, always.
All right. But you were wrong, right?
Apparently I was.
And you spell out for us the other day that you do make mistakes, isn't that correct?
Just like everyone else, I certainly
Well, we're
do.
not talking about everybody else right now, we're talking about you. You make mistakes, is that right?
I certainly do.
Overruled.
You make mistakes, is that correct?
Mr. Cochran, I make mistakes.
All right.
Yes.
And with regard to these theories that you expounded yesterday, you will agree with me, will you not, that with regard to what happened on June 12th in the late evening hours, ultimately must be decided by this jury and not by your theory. Isn't that a fair statement?
That's argumented.
Well, see if I can restate it. All right. You will agree with me, will you not, that as to the facts of this particular case, that has to be determined. Oh. I'm
Go
going
ahead.
to finish the question.
Finish the question.
Right. You will agree with me, will you not, that as to the facts of this particular case, the facts in this case must be determined by the jury. It's not the exact same question.
Oral. Yes or no?
Yes.
A truism.
Right. Absolutely a truism. Now, well, I'm not asking for opinion, Your Honor.
Fine. Well, you got mine. Let's move on.
I've got yours. Right. I have to deal with yours, but not hers. Thank you. Now, with regard to your theories, you've been wrong and mistaken in this case before, isn't that correct? You made mistakes in this case?
There were mistakes made.
Well, I know there were mistakes made, but did you make any mistakes?
I believe you just pointed one out in my testimony.
Well, there are others, aren't there? What about, let me just ask you this, regarding mistakes. The blood on Miss Nicole Simpson's back, you saw that at the scene, isn't that correct?
That's correct.
That blood was not preserved. Is that correct?
That's correct. The coroner did not preserve that blood.
So that was the coroner's mistake, not yours?
I'm not pointing fingers as to whose mistake. I think that there was a communication problem, certainly at the very least.
Well, as the investigator in this case, if that was possibly important evidence that may have led to the exclusion of Mr. Simpson, do you think that it would have been good to communicate that to the coroner's office so that would have been maintained and preserved and tested? He's talked about communication, Your Honor.
Overruled. You can answer the question.
That was communicated to the coroner's office,
And who'd you communicate that to?
to the coroner's investigator at the scene.
And you communicated, they both were speaking English, is that correct?
Yes, we were.
And then you found out sometime later that those results, so the blood had not been tested or examined or collected, isn't that correct?
That's correct.
Did you talk to the person you spoke to about that
Yes,
afterwards?
yes.
And what's that person's name?
I believe it's Mahaney.
Mahaney, is that a criminalist at the coroner's office?
Yes.
So it was Mahaney's fault?
I'm not saying whose fault it was.
All right. What about the failure to preserve the stomach contents of Miss Nicole Brown Simpson? Whose fault was that that was thrown out?
I don't know that it was anyone's fault. I do know I'm not in charge of stomach contents or what occurs at the coroner's office.
Well, now, let's see. As an experienced investigator, and you know the importance of the stomach contents from a standpoint of trying to determine, as a factor in determining the time of death of an individual, and you're there at the autopsy, wouldn't you suggest to the coroners that it would be a good idea to save these stomach contents. Wouldn't you do that? And she's testifying, you're not.
Or
No.
You may answer. You wouldn't suggest that?
That's their call.
All right, you never suggested that in this case.
I don't recall ever suggesting the coroner to maintain any stomach contents in any case.
Now, you were present when Dr. Golden was doing this autopsy, is that correct?
Yes.
And you understand any logic at all in preserving and saving the stomach contents of Mr. Goldman while not preserving and saving the stomach contents of Nicole Brown Simpson?
Overruled.
I see logic in examining both contents, and
Yes.
that was done. As far as their policies on preserving stomach contents, I'm not familiar with it. I don't know how long they do that or under what circumstances. I just don't know.
Well, now, you've attended more than 250 autopsies in your long career, isn't that correct?
No, I don't think so. It's probably more like 150. somewhere in that area.
150 autopsies. And in those cases where time of death is at question, isn't it accepted in the community of investigators and criminalists that the stomach contents are one important factor in helping us determine the time of death, sir?
Overruled.
Yes or no? It may be, and it may not be. It's one factor, and it's not an exact factor in determining death, the
Right.
time of death.
But in this case, it was thrown away, so we don't have it at all, and that's the point. Isn't that a mistake?
I can't say what's a mistake. I know that it was examined, and to me, it would be much more important to examine those contents and make a determination just how full a stomach was.
And who
as far as
examined?
retaining those contents, again, I don't know what their policies are.
If the coroner's office admits that's a mistake, would you agree that's a mistake since it's their field?
Sustained.
Now, talking about other mistakes, with regard to your report, which indicated that you booked 2 dimes and 2 pennies, do you recall that?
Correct.
And in fact, you told us on the stand here you only booked 1 dime and 1 penny. Is that right?
I didn't book either. They were booked by the criminalists. I inadvertently wrote down 2 dimes and 2 pennies, when in effect it was only 1 dime and 1 penny.
Is that a mistake?
I'd certainly call it a mistake, yes.
When you told us under oath that you had seen these blood spots on the rear gate at Bundy, yet no photographs were taken of those blood spots on June 13th, 1994, would you consider that a mistake?
That, again, was probably a problem with communications. At a crime scene, the criminalists, the print people, the photographers, the other detectives are all given assignments. The detective in charge, while responsible for their overall performance, can't follow each technician around and make sure that they do every little thing that they ask of them. So you assign out jobs, and that particular assignment came under the purview of the criminalist. Unfortunately, it was not done.
Now I can get back to my question. Was that a mistake that wasn't done? That's the question.
Was it a mistake of mine?
I didn't ask whose mistake. I said, was that a mistake, Detective Lang?
I would call that a mistake, a
All right.
problem with the communications.
In fact, there were photographs taken of some spot on the front gate, isn't that correct, which we saw yesterday, number 116?
I believe so.
All right, but they weren't taken to the rear gate, right?
That's correct.
Now, that was a mistake, but that was someone else's mistake, isn't that correct?
You could categorize it as a mistake, yes.
Now, you'd agree with me, would you not, that since you are the lead investigator in charge at Bundy of this particular case, some of this falls on your shoulders also, does it not?
Certainly.
Now, by the way, the dime and the penny were found on the north side of the Jeep vehicle, is that correct?
I believe so.
And you were asked some questions about tire track marks. You recall that yesterday?
Yes.
And Mrs. Clark showed you a photograph of that alleyway where it was asphalt or whatever, some kind of black substance. You recall seeing that?
Yes.
Now, the area, however, where the tire track marks were was not in the alleyway. That was a different kind of material behind the garage area of Miss Nicole Brown Simpson's residence. Is that correct?
There were tire tracks
All right.
on that area, yes.
And I want to show you 2 photographs in sequence. Ask you some questions about them. We're going to show the court please, fence 1032, the fence 1033. And I want to ask you some questions about those. You'll use the elbow. First of all, can you see, we tried to place them in juxtaposition to each other and sequentially, they're on the Almo now too. Can you see what appear to be,
Objection to the characterization sequence.
Sustained.
all right, we've placed them, the two photographs together. And do you see what appears to be tire tracks on those two photographs, 1032 and 1033?
Appears to be, yes.
All right. And do you see also where the coins from those two different photographs, which are LAPD photographs, right?
I'd say so, yes.
That those coins have been moved, they're in a different position?
They appear to be.
All right, did you ever, as the lead investigator at Bundy, do anything to try and check or to check out those tire track marks there?
I observed the tire tracks when I was there and formed an opinion.
I didn't ask you about that. I said, did you ever do anything, did you call any experts out?
That was what I did.
You called an expert out?
No, I formed an opinion that an expert was not needed.
All right, so you made that judgment yourself, is that right?
Yes, I did.
And are you, in addition to being the homicide investigator, also a tire track expert also?
I know when tire tracks have been run over and over and over again, and that this is a very commonly used area back here for tires, and that you can't tell the age of a tire track, and then it would have been fruitless to go any further with it.
Did you ever talk to an expert about that?
I know of no expert in tire tracks. I know of criminalists and photographers who could have photographed this, but aside from that,
Did you talk to them at all?
no.
All right, so-
Regarding the tire tracks, no.
Yes. What you did, you made a visual observation, and you've given us your opinion now that there's no relevance in this particular evidence. Is that what you're saying? Is that what you're telling us, sir?
This is a driveway that it's very common to see tire tracks transpose over
I'm
one
asking
another.
you whether there's
That's my
relevance
opinion.
in this evidence, Your Honor.
Wait. Mr. Cochran, let the witness answer before you start asking the next question.
All right, I was trying to get the question here. So
My opinion.
Hold on. One at a time.
let me ask you again. You looked at these tire tracks as depicted on 1032 and 1033, and you made a decision that you didn't need to talk to any further expert about this. You gave us your own opinion in that regard. Is that correct, sir?
Yes.
All right. And by the way, could these photographs show different dimes and pennies?
Could they show different?
Yes. Are those different dimes and pennies, or are those the same, if you know?
They're in a different position, so I can't say for sure.
You told us you only booked one dime and one penny, right?
The criminalist booked one dime and one penny.
Right. But what did you see out there that night?
My recollection is one dime and one penny.
But you wrote 2 dimes and 2 pennies, is that right?
Objection, ask the answer.
Overruled.
I wrote 2 dimes and 2 pennies incorrectly. I observed 1 dime and 1 penny in the driveway.
Can you tell us, in looking at the monitor, whether or not there are tread marks under these coins?
I can't see under the coins.
And could you tell whether or not there were tread marks over the top of the coin?
Doesn't appear to me to be.
And you did it with your naked eye, did you?
I observed the coins with my naked eye, yes.
All right, these photographs that we're looking at, 1032 and 1033, were taken while you were there or at some later time, if you know?
I would say the top one was probably taken while I was not there. As far as the bottom one, it's hard to say.
You don't recall?
Well, I was doing a lot of things in a lot of other places.
Do you
and
recall, is the question.
I do not specifically recall that bottom photograph being taken, no.
And with regard, however, to the material with regard to the tire tracks, when you were talking yesterday about asphalt, this is not asphalt back there, is it?
No, that appears to be cement.
Some kind of cement, is that correct?
That's correct.
All right. Now, you were asked yesterday some questions about your taking evidence and holding it someplace and not booking it for a period of time. Again, your LAPD manual, which you use as a guide, directs you to book evidence as soon as possible. Isn't that correct?
Generally, yes.
And where in in the manual does it say that you can take an item like the plastic heart and put it at robbery homicide for 7 weeks? Is there a particular section that tells you can do that?
I don't know of any section
Because there is no section that says that, is there?
that says that I can keep a plastic heart.
Well, it says you can keep any item of evidence for 7 weeks without booking it into evidence in this case.
There's nothing to say that I can't.
In other words, you could take every piece of evidence in this case and hold on to it for 7 weeks if you want? in a manual that says you should book evidence as soon as possible? Is that what you're telling us?
I think it's a common sense call. Certainly, I wouldn't keep every bit of evidence in this case. The evidence in this case was collected by a criminalist who booked it.
We're talking about evidence. Let's talk about the plastic heart. It was not booked until well into August. It was taken on or about June 13th, 1994. Is that right?
That's correct.
And in that instance, and we're talking about common sense and the manual, that instance, you would not hold evidence out generally for that long. Isn't that a fair statement?
There would be a purpose that I would hold any evidence out. Certainly, the evidence collected at the crime scene, save that plastic heart, would not have been held out by me, and indeed was collected and booked by the criminalist.
Well, what about the evidence that you talked about yesterday that was taken on the 13th but not booked to the 15th? What happened over the 14th, if you know?
What evidence would that be?
Well, you talked about evidence yesterday that Ms. Clark was asking you questions, you remembered, that was seized on the 13th, that showed a date of being booked on the 15th, I thought.
That's correct. That is the actual date that it was physically booked into the property division.
My question was, what happened on the 14th, which was the day in between, sir?
On the 14th, I believe the criminalist who had possession of that evidence was busy doing other things on this case.
Did the criminalist tell you that?
Did he tell me
Were
he
you
was?
told that?
I am aware that he was.
Is that your speculation that they were doing other
No.
things? Do you know the reason it was not booked on the 14th, sir?
The reason, in my mind, was the fact that this criminalist was doing other things, and I believe at that date working on the Bronco. There's also dozens and dozens of pieces of evidence that have to be categorized, written up, measured. Reports have to be prepared before this is actually physically booked into evidence.
Were you told that by the criminalist, is my question.
Was I told
Did
what?
the criminalist tell you they were busy on the 14th, and that's why they didn't book the evidence till the 15th?
No.
All right, that's just your opinion you just gave us.
That's my information. I was aware that he was doing other things.
All right, now, what about these Caucasian hairs on the gloves that we talked about? You indicated there were Caucasian hairs on both gloves, is that correct?
I believe you indicated that.
Well, I ask you if you didn't know that as the lead investigator in this case.
I'm aware that there were Caucasian hairs.
On both gloves, is that correct? Have any tests been done?
Objection. Counsel's not allowing the witness to answer.
I thought he was finished.
Proceed.
Are you aware of any tests that have been done on these Caucasian hairs that were on the gloves?
I believe there have been.
Counsel, ask a question. Can I ask a question? What did we last? Is it going to have a timestamp?
Nope. Are you aware of any tests that have been done on these Caucasian hairs that were on the gloves?
The question.
Oh, yeah. Can we approach her?
Yes. All right, thank you, counsel.
Thank you, Your Honor. Thank you very much. Detective Lang, do you recall whether or not there were Caucasian hairs found, let's take first the glove on Rockingham?
I believe my information was that there was, in fact, a Caucasian hair in that glove.
And were any tests conducted? Hairs that may or may not have been on the Bundy glove?
No.
The same answer as before?
Yes.
Now, did I understand your testimony yesterday to indicate that you had someone bring you the glove that was allegedly found at Rockingham over to you at Bundy? Did you so testify yesterday?
The glove was already at Bundy because that's where the criminalist had just come from. So he came to Bundy, and at that time I requested to take a look at the glove.
Had you asked to have that glove brought over?
No, it was brought over with the criminalist after he concluded his investigation at Rockingham.
And so we're clear about the criminalist. What criminalist are we talking about?
Mr. Fung.
And how did he bring it over, if you know?
He drove over in his truck.
And, well, other than by the truck, where was the glove when you first saw it?
In a brown paper bag.
And was anything else in that bag?
I don't recall seeing anything else in the bag.
And you told us yesterday how you examined this particular glove. Do you recall that?
No, I believe I just said that I looked at it briefly, and then we went over to the truck, and I examined it further at the rear of his truck.
All right, let's go back. Where were you when you first saw the glove that allegedly had come from Rockingham? Where were you in relation to the Bundy location?
I was at the rear of the criminalist van.
And what time was this?
Yeah, I could only estimate.
Your best estimate, what time was it?
I mean, perhaps 10:30, 10:45, 10:20, I don't know.
All right, and you saw it, Fung had it in his hands at that point, is that right?
No.
Where was it?
It was in a brown paper bag.
All right, well,
He
I'm
brought
asking-
it over to me at the scene and said he had it and suggested that we go to the truck to look at it, which we did.
The question was, did Fung have the paper bag in his hand at that time?
That's my recollection.
All right, that's what I'm asking you. And then at that point, did you visually look inside the bag?
Again, I don't believe I did at that point. We walked to the truck, and that's when I looked inside the bag.
All right. And when you walked inside the truck, who was present inside that truck when you looked inside this bag?
Okay, we were at the rear of the truck. Fung opened the bag and showed me the glove.
Can you answer my question? Who was present inside the truck at the time you looked inside the bag?
Fung and myself.
Just the two of you?
That's my recollection.
All right. And, of course, you've written all this down in your report. You wrote this down in your report, did you not?
I wrote what down?
The fact that you saw the glove, the back of the criminalist truck, along with you and Fung. You wrote that in some report, didn't you?
No.
I can't hear you.
No.
That's not written anywhere in any of your reports, is it?
I would have had no reason to write that down.
The answer is that written anywhere in any of your reports, Detective?
My answer is, Mr. Cochran, no.
All right. And you have never before yesterday ever testified about that. Isn't that right?
If I haven't been asked about it, I certainly wouldn't testify about it.
Let me ask you this. Did you ever before yesterday afternoon ever testify about looking at the glove allegedly taken from Rockingham at the Bundy scene along with Mr. Fung? You ever testified to that before?
I've never been asked that.
All right. There's never been any of your reports. Is that correct?
There would have been no reason to put it in any report.
The answer is no?
It's correct.
Now, so when you then looked inside the bag, inside the truck where you and Fung were, did you have occasion to touch the glove at that point?
I did not.
Did you take the glove out?
No.
And did you ever do anything with regard to the other glove, the so-called Bundy glove? Did you bring it over and look at it?
I didn't touch it.
You never touched it at all that day?
The Bundy
The
glove?
Bundy glove.
I don't recall touching it at all.
By the way, with regard to this evidence that was moved that you were talking about yesterday, and you told us how these bodies were in close proximity, did you see the evidence moved as the bodies were moved? And by the evidence, I mean the cap, the glove, and that envelope. Did you see that evidence moved?
No.
I'm asking cross-examination. Did you see evidence moved in this case?
I didn't physically see it, no.
But when I was originally with you on cross-examination, I showed you those photographs. You acknowledged the evidence had been moved. Isn't that correct?
It was obvious to me it had.
And that's the first time ever, in this case, you ever became aware that the evidence had been moved. Is that right?
When you showed me those?
Yes.
No.
You knew it before that?
I observed the photos prior to that, yes.
All right. And did you go and write a report about that, detailing how and when that evidence had been moved?
I wouldn't have known how and when.
Oh. You may answer.
No.
You've never written such a report, have you?
No.
And with regard to things like the ice cream. You never bothered to test the melting rate of ice cream until I started asking you questions. Isn't that correct about that?
Till you made it an issue, that's correct. It was of no evidentiary value to me at all.
Well, as the investigator, again, if you made one of your mistakes that you make on occasion, perhaps we called it to your attention. And now you're now testing ice cream. Is that correct?
It's argumentative. It's also badgering the witness at this point.
With regard, let me rephrase it, Your Honor.
Please.
With regard to the ice cream, the first time that you ever did any tests regarding the ice cream was after we started talking about it here in court. Is that correct, sir?
After you made it an issue, that's correct.
And so the answer is yes?
Yes?
All right. And with regard to, let's talk about the ice cream. Yesterday, in response to one of Ms. Clark's questions, you indicated that about seeing some substance in the ice cream. Do you recall that?
Some substance
Yes. You remember you said something about seeing something inside the ice cream?
that appeared to be,
Hold on. Detective, let him finish asking the question before you start answering, please.
okay.
Do you remember so testifying about seeing something in the ice cream after it melted, sir?
I remember saying I believe there was something lumpy.
And do you recall being asked questions about that earlier, about the ice cream, in my examination, when I asked you some questions about that?
Yes.
Do you recall being asked this series of questions and giving these answers? Counsel, it's at page 15369 and 15370, they printed out of the trial transcript. Tell us what you saw when you went in through that door, sir, went upstairs. Answer, I entered up the stairs, and to the left was a banister, which I observed a Ben & Jerry's ice cream cup. It was pointed out to me by Detective Phillips. To me, it appeared to be melted or melting. I asked Detective Phillips if that had been observed earlier. He stated, there's an objection by Ms. Clark. He gave you some information about the observations of the first officer on the scene? Answer, yes. Question, did you observe what kind of ice cream that was? Answer, no. Remember so testifying in Ms. Clark's direct examination that you didn't observe what kind of ice cream that was at that time? Remember so testifying?
Yes.
Now, yesterday, when you were asked, you told us that you thought it might have a lumpy area in the center. Is that correct?
I believe I was asked if it had something like that, yes.
You didn't tell us about that before, did you?
I believe I was asked about that before.
Now, with
Overruled.
Now, with regard to your investigation into the ice cream and the type of ice cream, when did you start that investigation?
As to the melting rate, I believe it was last week, perhaps the week before.
The week before, meaning, let's look at the calendar. Which week are we talking about? The week of February the 20th, sir?
I believe it might have, in fact, I believe it might have occurred on the, yes, I believe it was that week, 20, 21, 22.
In that area?
I believe so. I could be mistaken.
And in the course of your investigation, have you talked to a young lady by the name of Berman at all?
Have I?
Yes. Have you or anyone in your direction, sir?
I believe someone may have. I didn't.
I mean, in the course of this investigation, it started sometime the week of the 20th, I'm talking about now.
In regards to the ice cream?
Yes, sir.
I have not since then, no.
You've not since then?
No.
Who else have you talked to in the course of your investigation?
I spoke with the Brown family and the children through the Brown family.
All right, anyone else?
Detective Payne, who I requested to conduct this examination.
And examination, when you say, you mean investigation?
As to the ice cream, the examination of the melting rate of chocolate chip cookie dough.
So you had him go out and buy some chocolate chip cookie dough and then try to see how long it took to melt? Is that what you did?
Essentially, that's what we did, yes.
Were you present when Detective Payne did this?
No.
Were you able to ascertain how many members of the Brown family on that particular night purchased ice cream?
I was told how many purchased ice cream.
You were told that by the Brown family?
That's correct.
Brown family.
I'm sorry.
The Brown family?
Do we have any Brown family members present at the quorum?
All right.
Proceed.
All right. In regard to Detective Payne, just a second here. With regard to Detective Payne, has he given you a report of his findings regarding the ice cream?
I have photographs.
And in those photographs, are they taken in a sequential fashion so that you are able to determine how long this particular ice cream would take to melt? Is that right?
Yes, in 5-minute increments.
All right, and you found out that that particular ice cream would melt in a little more than an hour, isn't that right?
Approximately an hour and 15 minutes under those conditions.
So if that ice cream was solid at 11 o'clock, someone was eating at 11 o'clock, you would expect that it would be melted then by about 12:15 or thereafter, is that correct? Or in a melting state?
Not if it had been placed in a freezer.
Well, I didn't ask you that. I asked you whether if the ice cream was eaten by somebody at 11 o'clock and it was seen an hour and 15 minutes after that, you would expect it would be melted. Isn't that right? Under your test? I'm asking.
Sustain.
Basis, Your Honor?
Foundation.
All right.
Speculation.
Okay. Now, with regard then to this ice cream, you were able to find out that this ice cream would melt in about an hour, hour and 15 minutes, testing it in 5-minute intervals. Is that right?
Under the conditions that we had, yes.
Now, if Risky found the ice cream still melting at 12:40 a.m., and you extrapolate backwards, would that mean that the person may have been eating that ice cream as late as 11:15, 11:30?
I couldn't say.
All right, well, you have this test from Detective Payne, don't you?
Well, I have this test, but this test isn't the definitive answer as to melting ice cream. If you had placed this ice cream in the freezer and refroze the ice cream, it would change everything.
Well, do you think someone placed this ice cream in the freezer when you know, in fact, that the ice cream was found on the banister where it was when you found it, sir?
I don't know when it was last frozen. It may have been placed in the ice cream prior. I don't know.
I see, sir. All right, at any rate, your investigation on the ice cream continues. Is that correct?
That's correct.
And you're doing other investigations also, isn't that correct? That continues, that you've started after this trial, isn't that correct?
We get information on a daily basis, and we conduct this investigation on a daily basis. Everything is ongoing.
Do you ever investigate any clues that lead away from Mr. Simpson? Have you done that?
Yes.
All right, what clues have you conducted? May I have just a moment, Your Honor? Maybe approach for a second.
Sure.
Detective Lang, why don't we come back to the clues and what you pursued after lunch, if you don't mind. Let me ask you some questions about your theory about this not being a drug-related homicide. You ever heard of something called a Colombian necklace?
I believe so.
And it's true, is it not, that a Colombian necklace is a situation where drug dealers will slice the neck of a victim, including the carotid artery, in order to kill the victims and to instill fear and send a message to others who have not either paid for their drugs or have been informing to the police. Isn't that what a Colombian necklace is?
I've heard that.
And, sir, isn't it true that you, in your experience, know about drug killings where knives have been used? Isn't that correct?
I do have knowledge of knives being used, yes.
And, sir, in this connection, you are aware, are you not, that Faye Resnick became a resident at Nicole Brown Simpson's place at 875 South Bundy on or about June 3rd, 1994. Isn't that correct?
No, I'm not.
All right, your superficial investigation didn't reveal that?
Initially, the investigation revealed she may have been. I've since received information that she was not a resident at that location, and that is ongoing.
You're still looking at that?
Yes, we are.
All right, well, in the course of your investigation, have you learned that she moved in with Ms. Simpson on or about June 3rd, 1994, and stayed there until June, may I finish the question?
Finish the question.
And stayed there until June 8th, 1994, at which time she went into drug rehabilitation.
Sustained.
All right. Does your investigation reveal that Faye Resnick went into drug rehabilitation on or about June 8th, 1994, and that she was living at Nicole Brown Simpson's?
Sustained.
I'm asking this investigation, Your Honor.
Counsel, it's a compound question.
All right. Let me restate it then, Your Honor.
All right.
In the course of your investigation, did you learn that...
Wait. That assumes that something is a fact. Did you consider, when he formed his opinion, did you ever consider these three factors?
Thank you, Your Honor.
And it's only on the basis of forming an opinion, not assuming it to be true.
Thank you, Your Honor. In the course of your forming your opinion,
They will, as soon as I hear what the question is.
in the course of your investigation in this matter, and your determination that this was not a drug killing, did you consider the fact that Faye Resnick went into a drug rehabilitation facility on or about June 8th, 1994?
Oral.
Consider that fact?
I have been told that she had.
The question is now, not what you've been told, sir. Did you consider that fact when you came to this conclusion you told us about yesterday?
When I came to that conclusion I told you by yesterday, I didn't have that knowledge.
All right? So there are other facts that are coming into your knowledge even as we speak in this case, is that correct?
Every day.
All right? Now, if, and I want to ask this as it relates to your opinion, if Faye Resnick was freebasing cocaine on a daily basis at the Bundy location, so much so that she had to have a drug intervention by June 8th of 1994, and you learn that to be a fact, would that change your opinion about this possibly being a drug-related killing?
If I had that information, that would probably be a consideration if I had no other direction to go.
All right? And if you found out that as she used this cocaine and was freebasing on a daily basis, she had no job by which to pay for these drugs, would that be a factor that might bear upon the opinion you gave us yesterday? That's going to relate to his opinion.
Ladies and gentlemen, this is what counsel is posing to the detective, or what are known as hypothetical questions. The witness is asked to assume to be true certain facts and then asked to give an opinion based upon those assumed facts. If those assumed facts turn out not to be true, then you can take that into consideration in evaluating the opinion that is given. Mr. Cochran.
Thank you. I don't think we had an answer to the last question. Do you want the question read back for you?
I think I understand it. If I had been pursuing that line, that certainly would be a factor I'd look at, yes.
And you understand that when individuals get drugs, they sometimes will pay for them in cash. Sometimes they get them on consignment. Isn't that correct?
I've heard of that.
And in your experience as an experienced police officer, when people are given drugs, the drug dealers or the people who give those drugs want to be paid. Isn't that correct?
I would assume that.
And sometimes in your experience, you know that when drugs are not paid for that have been gotten and used, there are repercussions. Isn't that correct?
Certainly.
And hence, sometimes, and that's why you've heard this term, Colombian necklace. Isn't that correct?
I've heard that term, not necessarily in connection with every murder I've ever handled.
Well, it can also be for payback for not having paid for drugs. Isn't that correct, though, sir?
I suppose it could be.
And in the course of your investigation, if you were to learn that Faye Resnick was in this drug treatment facility on June 12th, 1994, and that she, in fact, called Ms. Nicole Brown Simpson that evening from the drug treatment facility. Would that be a fact that you might find relevant in the course of your investigation and your opinion regarding whether drugs were related in this manner?
Again, if I were pursuing a drug-related homicide, that would probably come into play, yes.
And would it be relevant to you if you were pursuing a drug-related homicide that Ms. Nicole Brown Simpson was present at the intervention in which family and friends of Faye Resnick, including Nicole Brown Simpson and her former boyfriend, Christian Reichard, insisted, because of the state of her freebasing cocaine, that she go and get some help that same night and leave Nicole Brown Simpson's residence? Would you consider that as one of the factors if you were pursuing this as a drug-related homicide?
If I were pursuing it as a drug-related homicide, I would probably want all of those factors, yes.
In other words, as an experienced investigator, you'd want to know all of those things, and you'd want to determine what bearing, if any, they had. And that would be more than a superficial investigation. Isn't that correct?
If it led in that direction, certainly.
Very well, Your Honor. Maybe we stop this one.
All right, ladies and gentlemen, I have a couple of matters I need to take care of out of your presence. I'm going to excuse you for lunch now. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. All right, let's excuse the jury, and let me see Mr. Walsh and one counsel from each side at the sidebar, please. Not present. Mr. Cochran, anything you want to address or bring up before we invite the jurors to rejoin us? And Mr. Robertson, would you ask if Mr. Hodgman will be down here at 3:15 so we can clear up some of those things? Mr. Scheck, any items we can clear up so we can turn you loose for the afternoon? Any items we can take up with you so we can turn you loose for the afternoon? He mentioned he wanted to...
We submitted a letter to the court with the transcript of yesterday's testimony with the witness and some of the colloquy, and made a proposed curative instruction. And I think our letter speaks for itself, and I would urge the court to give the instruction as written.
Okay. Ms. Clark?
Yes, Your Honor, the people have also submitted the proposed admonition. I think that counsel's letter is an extreme exaggeration of both the importance and the impact of the question and answer that are an issue, and the requested admonition goes far beyond the pale of anything necessary. We all know this testimony is going to occur. This evidence is going to be presented. Counsel's proposed admonition makes it sound like there was a devastating thing that occurred in court yesterday, and that's not the case. That's simply not the case. I think that if anything is at all required here, it's that the answer and the question be stricken, period.
All right. Thank you, counsel.
Reaction to that, I think it's clear from the letter the difference between the curative instruction that we offered and the one the prosecution offered is that we are essentially saying that the questions were improper, but that Detective Lang does not have the scientific training or qualifications to state an opinion about these test results, and you're instructed to disregard his answers. I think that is reasonable and plain, and I think as I lay out in this memo, the prosecution is well aware of the scientific issues with respect to the blood scrapings and the tests. They're subtle, they're complicated, and I think that they plainly gained a tactical advantage here. And in looking back at the record, I think it was much more egregious than any of us thought. First of all, the question, are you aware of the results of those scrapings, the DNA tests, that the DNA tests on the nail scrapings? Yes, I am. And did that testing reveal the blood to be hers? Yes. Now, that question, everybody knows is improper because no DNA test can do that definitively. But more importantly, the prosecutor yesterday indicated that she was trying to raise this in the first place just to show how as obliquely, just to show how this detective's investigation or the focus of his investigation changed. And that really can't be the case, because these tests were performed after the trial started. So to be claiming that she was asking these questions to focus, to explain how the detective's investigation went before the trial started, is illogical and without any factual basis. I think what was clearly going on is Ms. Clark was trying to elicit DNA test results from a witness who was not qualified to do so in order to gain a tactical advantage in terms of when the testimony would come out from the scientific witnesses, where it will come out quite differently in terms of direct and cross of the proper witnesses. So I tried to craft an instruction that was limited, particularly in light of the discovery violation, and it seems to me perfectly plain that Detective Lang, who seems to have far-ranging expertise in lots of areas, but I'm sure one of them is not, that he is qualified to state an opinion about these DNA test results, and it seems fair to tell the jury to disregard it, because I think that's the way we were prejudiced.
All right, thank you, counsel. If you feel compelled.
Only that the curative instruction requested is inappropriate. The question was neither inappropriate nor improper. The only issue was discovery. I, in good faith, believe that they knew of these results, and that's really the issue I thought the court was addressing. And Mr. Detective Lang did not offer a scientific opinion of any kind. He simply indicated it did not change the focus of his investigation. And that had to do with the impact on his state of mind, the issue as to rush to judgment, the issue as to his theory of the case, which is continuing to be a line of cross-examination that is being engaged in by counsel. Obviously, the response to that line of questioning is there's a wealth of physical evidence that indicates that these are not drug-related killings, that this is not the result of some Colombian cartel or some mafia killing. And that's what this line of questioning goes to. It was opened up on cross-examination when counsel began to ask about drug-related killings and other motives. And in response to that, the people were appropriately entitled to say, what led you to file, and what leads you to conclude to this day that you have made no mistake in requesting the filing in that manner? And I mean, that's the big picture. That's where this all fits in. And there's no effort to mislead or confuse a jury. Quite the contrary. The court knows that the people will present witnesses, experts, to testify in much more detail as to the nature of the testing and those results. But at this moment, all we were asking to do was ask Detective Lang to testify to his state of mind and why he bases his opinion, what he bases his opinion on, and why he does not believe it to be drug-related killings. So I mean, it's a totally separate line of inquiry. Mr. Scheck is missing the point. What the court, I thought, wanted to address was what turned out to be a discovery issue, which the people were, I was not aware it was a discovery issue, knowing that the defense expert was standing over their shoulder literally when the testing was done. I think I'm entitled to believe that they would know what those results were, and I'm not so sure that they didn't. Nevertheless, I understand the court's concern. That's why, at best, the court should instruct the jury to disregard the question and answer and advise them that that subject matter will be taken up by the expert witnesses at the appropriate time.
Right,
and I think that more than adequately covers the situation.
All right, thank you, counsel. I think we've exhausted our discussion on this. All right, Mr. Cochran, you had one other matter that you broached before we broke.
Yes, just an area of inquiry, briefly, Your Honor. With regard to the prosecutor elicited some testimony that this detective followed up all of these leads and clues and everything. And I think the question I pondered, proffered, was whether or not he'd followed up any clues or leads that had pointed toward Mr. Simpson's innocence, and I wanted some documentation of that. That was the area we were looking at, just briefly.
All right, I had sort of anticipated you were going to launch into a litany of 450 leads that were otherwise.
No, Your Honor, I mentioned to the court yesterday, you should never presuppose anything with regard to me. I think that I'm perfectly capable of telling the court that's all I'm planning to do. And that's what I wanted to ask. I wanted to ask him about it. In fact, we can ask him now.
Then I misunderstood the import of your comment.
Sure.
All right,
Right.
Then let's proceed.
May I approach, Your Honor, with the witness a minute?
Sure.
With regard to that? Thanks.
Ms. Clark? Ladies and gentlemen, Detective Tom Lang is still on the witness stand on recross examination by Mr. Cochran. Good afternoon again, Detective Lang.
Afternoon, yeah.
You're reminded you're still under oath. Mr.
Yes.
Cochran, you may
Continue.
continue
Thank
your
you, Your Honor. Thank you.
cross-examination.
Good afternoon, ladies and gentlemen. Good afternoon, Detective Lang.
Afternoon.
With regard to the clues that you spoke about, I guess, yesterday and this morning, that you've investigated, are there some clues that other members of your team have pursued that would be of an exculpatory nature as they relate to Mr. Simpson that would point toward his innocence?
Possibly of an exculpatory nature, yes.
And there are some clues like that you have not personally investigated, is that correct?
I believe so.
And would Detective Payne be one of those who've looked at those clues?
Detective Payne supervises the assignment of those clues to a great extent and has those clues in his computer.
And if I would ask you to search through your computer to give us a computer run of the number of those clues and what the status of them of those clues are, could you do that over a period of time?
Yes,
And are you willing to do that?
certainly.
And do you have a ballpark estimate of how many such clues there are now pending?
I would have no idea except to state that they've all been turned over to you. I haven't reviewed personally each and every one, so I don't have any idea.
And in that connection, as I understand your testimony, those clues regarding innocence or whatever come in pretty much on a daily basis. Is that correct? Clues in this case?
No, not necessarily.
All right, but let me rephrase it. You still get clues in this case on a daily basis, isn't that correct?
Practically.
And so the investigation in this case will and must continue because of that. Is that correct?
That's correct.
All right. And so you'll try to get that for us, and if we can finish you today, you can perhaps bring that back at some later time. Is that correct?
Well, again, I've turned over all clues. It might be very subjective as to what is exculpatory and what is not. I might suggest that you have your people look at those also.
We will do that.
Because you may interpret something as exculpatory and I may not.
Okay,
So
one
I
person's-
really don't know.
One person's exculpatory may be another person's inculpatory. Is that what you're saying?
Certainly.
All right, we'll make that judgment, but you'll give us what you have. Is that correct?
We'll make that attempt, but again, I don't know exactly what you're asking for.
All right. Well, I appreciate you doing that. Now, with regard to the subject of ice cream, you said yesterday that photographs tend to memorialize what's at the scene, and that seemed to be a fair statement. And in this instance, you did not take any photographs of many of the things that were in the interior of that residence. Isn't that correct? Or
That's
have them
correct.
taken? And we've established previously that you didn't take any photograph of the ice cream, right?
That's correct.
Now, with regard to that, have you personally or anyone in your direction talked to a young lady, I believe is 8 years old, thereabouts, whose name is Rachel Berman?
I don't know if Rachel was spoken to or her mother. I believe her mother was.
All right. And with regard to the kind of ice cream that you had the detective do a test on, I think you told us that was some kind of, what ice cream was that?
Chocolate chip cookie dough.
All right. And were you also, did you run any tests on an ice cream flavor named Rainforest Crunch?
No.
Did you have information that Miss Nicole Brown Simpson that night did you have information that night? May I finish the question, Your Honor?
Yes.
In the course of your investigation, and did you have information that on the night of June 12th, 1994, Mr. Nicole Brown Simpson purchased an ice cream called Rainforest Crunch?
No, my information was the chocolate chip cookie dough, and I believe there was a chocolate chip.
And so your answer is no, you didn't have it. It was Rainforest Crunch.
That's correct.
So have you, in your voluminous materials, do you have any statement or have you read a statement from Rachel Berman, who apparently was with them that evening? Have you read that statement?
Oh,
Read a statement from Rachel Berman?
As to what kind of ice cream they purchased when they went to Ben & Jerry's?
No, I received that information through the Brown family as to what
All right.
each one of the three children purchased.
All right. Would you think it would be helpful from the course of you strike that. In your investigation, you learned, did you not, that the Brown family themselves were not with Ms. Nicole Brown Simpson and the children and Rachel Berman when the ice cream was purchased. Did you not find that out?
They just left them when they walked across the street. That's correct.
They weren't with them. Now, would it be helpful to you to talk to a child not involved in this case who was present when the ice cream was purchased? Would that be helpful?
That was done through the Brown family.
I'm asking you, would that be helpful for you to do that?
Yes.
Now, the Brown families, they aren't members of the Los Angeles Police Department, are they?
I was advised by the Brown family that I could not talk to the children, that they were under the care of a child psychologist, and so I respected that.
I understand. You told us that yesterday. I'm asking you now about Rachel Berman, not the Simpson children. I'm asking you, have you or anyone in your direction talked to that child individually?
As to the ice cream, no. Again, that was done through the Brown family.
Well, as the investigator, would it be helpful to you to talk to a child who was present, sir, and find out about the ice cream?
Yes.
Did you find out at any point that, let me ask you this, did you find out at any point in the course of your investigation that the flavors purchased were Rainforest Crunch? Did you ever find that out?
I don't recall Rainforest Crunch.
All right. Did you find out that one of the flavors purchased was chocolate fudge?
Yes.
Did you find out one of the flavors purchased was cookie donut?
I believe it was cookie dough. My information was 1 chocolate fudge and 2 cookie doughs.
All right, but you've not talked to Rachel Berman yet, right?
I have not talked to Rachel Berman.
Now, in this, bless you, you described for us that before lunch about these drug killings, and I asked you some questions about this Colombian necklace, and remember we talked about that?
Yes.
Do you know what a Colombian necktie is?
I've heard stories of Colombian neckties.
And what is a Colombian necktie?
My information is that it's a tire that would be put over someone's neck and set afire.
That's a Colombian necktie?
That's what I've heard. I've never experienced them.
Have you ever heard of a Colombian necktie being a situation where in a drug, I can ask this question, Your Honor, as an expert? Thank you. Have you ever heard of a Colombian necktie being a situation where in a drug killing, a person's throat is slashed and their tongue is pulled down through their neck area? You ever heard of that?
No.
All right. What you talked about was a necktie that used in South Africa, isn't it, where tires are put over someone?
I thought that's what you were referring to.
No, we're talking about Colombia, not South Africa.
Well, I don't know where these things occur. The
All right.
only necktie reference I've heard is with the tire.
All right, sir. Now, you were the detective on the Wonderland case, isn't that correct?
That's correct.
And was that a drug case? Involving
Yes.
drugs? Was that a drug case that involved knives?
No.
Was it a drug case involving killings?
It involved killing, yes.
Was there a knife involved in that case at all?
There were no knives involved in Laurel Canyon, no.
But in that case, there was a drug killing that resulted, in which you investigated, is that correct?
There were several. There were 4 of them, yes.
And how long ago was that?
That was in July 1st, 1981. 81.
Well, now, this morning I asked you some questions about Faye Resnick, and you are aware, because you have seen records subpoenaed from a drug treatment facility called Exodus, isn't that right, regarding Faye Resnick? You've seen those records, haven't you?
I don't recall seeing any records like that.
You're the lead investigator in this case, and you've never seen any records from a drug treatment facility called Exodus?
Faye Resnick became a witness after this case was filed and dealt with the district attorney's office, and I wasn't present for those interviews.
I understand all that, but have you ever seen those records from Exodus?
Again, I don't recall ever seeing those records.
Have you had occasion, in the course of your investigation, to have a review of this book allegedly written by Faye Resnick?
I have read the book.
You have read the book?
Yes.
And when did you read the book?
Shortly after it came out.
And in that book, or after reading the book, if it's to be believed, you became aware, did you not, that Faye Resnick had had a history. Finish the question?
Finish the question.
Became aware I finished the question, Randy.
All right, why don't you push the court quickly? Thank you, counsel. Proceed.
Detective Lang, in the course of forming your opinion, this was not a drug-related, these were not drug-related killings. Did you take into account, in forming that opinion, whether or not Faye Resnick had moved in with Ms. Nicole Brown Simpson on June 3rd, resided there until June 8th, at which time she went through an intervention with friends and family into a drug treatment facility called Exodus, where she was still in on June 12th, 1994.
Initially, I didn't have that information. Subsequently, I received information she did not, in fact, move in with her permanently.
I
All
didn't,
of
ask, I didn't ask if she moved in permanently, sir. Can you get back to my question, if I can? Let me see if I can get it back to you so you're clear. The question was, would, if she lived there from June 3rd through June 8th, whether permanently or not, but during that time frame, and on June 8th, she went into Exodus, the drug treatment facility, and on June 12th, she was still in that drug treatment facility, would that have affected your opinion regarding whether or not this was a drug, possibly a drug-related killing?
Did not have that information.
All right, you didn't have the information. We understand that. Now, if you had that information, would that be something that you would want to check out?
If I felt that there were drugs and this was a drug-related murder, certainly. But
All right.
that wasn't the evidence that I had, and that wasn't the path that I pursued. I had nothing to lead me in that direction.
I understand. You've since said you found out information since this happens, and you've told Ms. Clark, did you not, that investigations continue, sometimes even when the case is going on. Isn't that correct?
Correct.
Up to the minute this jury gets this case, the investigation may very well continue. Isn't that correct?
May well beyond that.
All right. And as a good investigator, don't you continue, and don't you, as an investigator, try to develop evidence as it comes forward? Isn't that correct?
If it comes forward, I certainly do.
All right. You don't turn a blind eye on evidence just because it might point toward Mr. Simpson's innocence, do you?
Just the contrary.
All right. So you would follow any particular lead, and any such lead regarding possible drug involvement would be important to you as an investigator. Isn't that correct?
If I felt that this case involved drugs or drug dealers, it would. The fact is, it doesn't.
All right. Well, I'm asking you, you said there's new information that you have afterwards, so that you've already made a conclusion in this case that no matter what you heard about drug involvement or Faye Resnick, you don't plan to look into that. Is that what you're saying to us?
No. The fact that the victim may have a friend who uses drugs, and in light of no other evidence in that regard, has very little consequence to me. The fact that every bit of evidence that I have in this case points towards the defendant has a lot more to do with this.
Every bit of evidence you have, is that correct?
That's correct.
All right. Well, so that you have made your own judgment. In fact, in this case, you submitted this case to Ms. Clark for filing, did you?
Yes, I did.
So you submitted for a filing on June 17th to Ms. Clark, right?
That's correct.
And then she then filed this case, right?
That's correct.
And before you submitted this case, you had heard or seen Ms. Clark on television saying this was a sole murderer case. Isn't that correct? You'd heard that, hadn't you?
Objection, Your Honor.
It's hearsay. Just
Well, did you ever hear Ms. Clark say?
though it's a question. There's no answer.
Did you ever hear Ms. Clark say, where you were present, this was a sole murderer case?
That's all. I'm going to sustain the court's own objection. That's irrelevant, what he heard Ms. Clark say.
Well, when he gives this theory, I have a follow-up
Well.
question. All right. At any rate, when you filed this particular case and you told us this theory was a sole murderer, was that your theory or Ms. Marsha Clark's theory?
My theory has always been there is one murderer.
Was that your theory or Ms. Marsha Clark's theory?
I don't know what her theory is. I believe her theory is the same as mine.
And you've discussed that with her, have you not, during your many conversations?
As to the one-person theory,
Yes.
it's been brought up.
All right, and when you discussed it and you went over your testimony last week before you testified yesterday, you talked about that, didn't you?
The fact that we believe there's one murderer?
Now, talked about the one murder theory, yes.
Yes.
All right, and you were prepared when she asked you those questions yesterday, isn't that correct?
Yes.
Now, in that connection, you told us that you read Faye Resnick's book, right?
That's correct.
And so that we're clear, you're saying to us that even if you knew that Faye Resnick had lived at the residence of 875 South Bundy and had used drugs at that residence between the period of June 3rd to June 8th to such an extent that she had to go into a drug rehabilitation facility and that she had no job by which to pay for these drugs,
Objection, Your Honor.
and that,
Objection.
may I conclude, Your Honor?
That's on the evidence.
Overruled.
And that as of,
Hypothetical question.
thank you, and as of June 12th, she's still in that facility. You're telling us as an experienced investigator, that wouldn't cause you to even or to consider that this might be a drug killing. Is that right?
I didn't base my investigation on what I read in the book. I based it on the facts and the evidence that I had.
That's what I'm asking you about, based upon the facts and the evidence. Is there any doubt in your mind as you sit there now that Faye Resnick was in Exodus, a drug treatment facility, on June 12th?
Objection, irrelevant, hearsay.
Overruled.
I don't know if she was or not.
As an investigator, have you checked that out?
Personally, no.
All right, so you haven't. So would that be something that, as an experienced investigator who wanted to get at all the facts, wouldn't you want to check that out?
Not when that was being handled by the district attorney's office after the case was filed.
Not when what, sir?
The interview of Ms. Resnick and her background is being handled by the LA District Attorney's Office subsequent to filing.
But didn't you tell us the other day that Van Adder interviewed her also, was present at that interview?
He was present during the initial interview, that's correct.
And you're both co-lead investigators, isn't that correct?
That's correct.
And don't the two of you ever talk about this case?
All the time.
And has he ever discussed with you what Faye Resnick said?
Not to any great degree.
You never talked about it?
We've talked about certain things,
And-
but again, not to any great degree.
It was of no interest to you so that it would cause you to want to go out and check out that possibility of a retaliation for failing to have paid for drugs obtained after June 3rd, 1994.
Objection. This is
Sustained. It's a hall problem. That's a hall problem.
Thank you, Evan. Now, you mentioned also that you searched the Nicole Brown Simpson home for various things. When did you conduct this search for the drug paraphernalia and and things of that nature? When was that?
I've been through the house on several occasions, beginning on the 13th.
On the 13th, I thought you told us earlier that you just basically went through the house and you left by 12 o'clock. When was it that you searched for drugs during that period of time?
On the 13th, I looked for drugs, drug paraphernalia, drug debris.
Had drugs come up by that time?
Have drugs come
Had
up?
drugs come up by the time you were searching on the 13th?
I saw none.
No. I'm asking you, you said that you were searching for drugs. What was making you search for drugs on June 13th?
That was part of my superficial investigation. I always check for things such as drugs, handguns, large amounts of money, things of this nature.
And part of your superficial investigation took how long? About 15 minutes?
No, I believe I was there for several hours.
Well, we know you were there for several hours, but how many times, how long were you searching?
Within the house?
Yes, inside the house, the interior of the house.
I was probably in and out of there several times, perhaps as long as an hour and a half, 2 hours. 2 hours and 45 minutes, it's hard to say.
And how much of that time was spent searching, Detective?
I'd say the whole time was spent looking at things, noting things.
And while you were doing this, you, by the way, didn't take any photographs of that interior other than the knife and the things down on the kitchen counter. Is that right?
The only photographs taken at that time were of the knife on the counter, yes.
Is your answer yes?
Yes,
That the-
yes.
All right. So you didn't take any photographs of anything that you searched and any drawers you looked in upstairs. Is that correct?
That's correct.
Did you ascertain and find out which room Faye Resnick might have lived in that house from June 3rd to June 8th when you were there on the 13th?
I didn't know who Ms. Resnick was at that time.
All right, so you didn't know where to look. Is that a fair statement?
I didn't know who she was or anyone else at the location. We had, and even earlier, had this victim identified till we found her identification in her room, and we made positive identification.
Your answer is you didn't look and you didn't know where to look as to which room Faye Resnick may have occupied. Is that right, sir?
I didn't know who Faye Resnick was.
All right? Well, when you found out who she was, did you go back and look?
No.
Have you ever personally talked to Faye Resnick yourself?
Yes.
And when was that?
About an hour and a half ago.
Today?
That's correct.
Over the telephone?
She called, yes.
Is that over lunch hour?
Yes, it was.
Is that the first time you ever talked to her?
Other than in passing and greeting, yes.
You were not present when she was interviewed before, is that right?
That's correct.
Now, as I understood your testimony this morning, did you indicate that you cannot tell us which of the two individuals in this case were killed first, neither Mr. Goldman or Ms. Brown Simpson? Is that correct?
That's correct.
And with regard to Mr. Goldman and the fight that he put up prior to losing his life, Dr. Erwin Golden, Goldin, is the forensic pathologist who did the autopsies in this case. Is that correct?
I believe it's Golden. Dr. Golden, yes.
Goldin?
Yes.
All right. He is the doctor, the expert. Is that correct?
He's the pathologist who performed the autopsies.
And you were present, and you've seen him testify at the preliminary hearing and other times in this case, have you not?
Yes.
And do you recall Dr. Golden describing the bruises and abrasions on Mr. Goldman's knuckles as follows? Counsel, this is from the preliminary hearing, page 96. Question, and in general, as in brief, how would you characterize those wounds? Answer, basically there are multiple abrasions involving the forearm, including the outer or lateral aspect of the forearm, where there are multiple abrasions. That means scratches. Some were not scratches. They were irregular in configuration. On the top of the hand, there were fresh bruises, abrasions on the knuckles. And I went into detail on which fingers and which knuckles. Remember him so testifying?
No.
You don't remember that?
I don't have an independent recollection.
All right.
I'm not saying it didn't happen.
Would it be helpful for you to read it yourself?
No.
All right. There are abrasions, bruises. I will link it up here.
Overruled.
There are abrasions.
Hearsay at this point. Sustained.
No, this is with regard to exception. May I approach? It's not hearsay. With regard to this one, is this his expert?
No. Sidebar.
Yes.
And you are aware of what he testified about these bruises and abrasions on Mr. Goldman's knuckles. Is that correct?
I'm aware he testified regarding those, yes.
And with regard to that, did you, prior to giving us your opinion yesterday about how Mr. Goldman may have gotten these injuries to his hands, did you ever discuss that with your expert forensic pathologist regarding what those bruises connoted and what they meant?
No.
So you gave us you're not a doctor, right?
That's correct.
And you gave us an opinion yesterday without talking to the doctor who's assigned to this case, is that right?
That's my opinion that I gave you. I wouldn't elicit my opinion from anyone.
All right, this was your opinion, right?
That's correct. That's what I was asked.
Now, with regard to whether or not these killings were done by one individual, again, at the preliminary hearing, did you have occasion to listen to Dr. Golden and his testimony of whether or not he believed there may have been two knives involved or used at the time? Well,
Sustained.
let me state it this way. Did you hear Dr. Golden's testimony about the number of knives that he found may have been used at the time of these killings? At the preliminary hearing?
Same question. Same question. If he heard the testimony of Dr. Golden, yes or no, did he consider that?
All right. Did you hear the testimony of Dr. Golden, again, at the preliminary hearing?
Yes.
And did you consider that testimony as it relates to weapons prior to forming your opinion that you gave us yesterday?
Yes.
And did you discuss that testimony with Dr. Golden yesterday before you gave us your opinion about the number of weapons involved here?
I didn't discuss it with him yesterday. I have discussed the one or two weapon theory with Dr. Golden.
You've done that in the past?
Yes.
Can you tell us when was the last time you discussed that with Dr. Golden? Well, strike that. Did you discuss it with him after the preliminary hearing?
I believe it was after, yes.
Did you ever discuss it with him before the preliminary hearing?
I don't recall if there's any discussion during autopsy or not.
Did you write a report based upon your discussion with Dr. Golden?
I wrote a report, notes initially at the autopsy, yes.
Now, I wanted to know, this was the conversation you had afterwards that you said where you talked about the number of weapons. Did you write a report about that conversation?
No,
So there's no report?
I don't believe there is. I'm not saying there's no report. I discussed this with another individual, and whether or not that individual made reports or not, I don't know.
In the course of your investigation, did you find any debris or any bark from a tree or anything of that nature on Mr. Goldman's hands or on any portion of his body?
I did not personally examine his hands.
All right, that's your answer. Did you find anything of that nature?
I didn't examine his hands, so I didn't find anything.
If you were to see a photograph of his hands, would you recognize that photograph from the autopsy at all?
If there was some identifier, perhaps, I couldn't just identify a hand, no.
All right, you were present at the autopsy and you observed these things, did you not?
That's correct.
Now, with regard to the hands of these two individuals, was your testimony yesterday that never in your experience as a homicide investigator have you ever bagged the hands of a victim other than in a circumstance where there was a gunshot wound? Is that what you said?
My experience has been that we bag the hands of gunshot victims.
Okay, you told us that, and from a standpoint of good forensic procedure, and have you read books on this subject at all?
On what, bagging hands?
Bagging hands and saving trace evidence.
Specifically, no.
You've never read a book on that subject, is that right?
Specifically on that subject, no.
Yes, sir.
No.
And in that connection, would you agree that the best way, or that experts agree the best way to preserve trace evidence is to bag hands and keep the hands separate? Would you agree with that?
I can't say that, no. I think it's important to attempt to preserve any evidence. There are different ways that one would go about doing that, and it doesn't necessarily include bagging of the hands.
But you've never read a book with regard to that, is that correct?
A book on bagging the hands?
Yes, a
No, I
book or any portion of a book regarding bagging of hands.
No.
With regard to the subject of lividity, which you talked about yesterday, have you ever read any articles or publications regarding lividity and what lividity is?
Yes.
And what did you read? What's the last thing you read in that connection?
Over the years, I've read several books. I've read criminal investigation, homicide investigation, various publications.
Do you know what the term blanching is?
Yes.
And what is blanching?
Blanching is the touching of the skin after death in the area that has lividity, in an attempt to see if that it would blanch if you touch, say, a red area that's lividity, you depress that area, and the blanching of the whiteness remains. There's a good possibility that the person has been deceased for 4 or 5 hours or longer. Generally, if the redness would return, it may indicate that that person has been killed within 2, 3, or 4 hours, something under the 5 or 6 hours general guide.
All right, now, what to you does the term lividity mean?
Lividity is the sinking of the blood in the human body subsequent to death to its lowest point caused by a gravitational pull.
And if you have a fair-skinned individual, it might show up more than if it's somebody who has darker skin. Is that a fair statement?
Well, it would depend. In this particular case, you had a victim with very little blood in her, and not necessarily under those circumstances.
Well, that was as to the one victim. Did you check lividity as to both victims, did you not?
Just from what I could observe, they were fully, with the one victim, Mr. Goldman, was fully clothed. I couldn't observe any lividity.
And Miss Nicole Brown Simpson was clothed also, was she not?
She was clothed, yes.
All right. And with regard to her body, what, if anything, did you notice regarding lividity?
Under those circumstances at the scene, nothing.
Did you try? Did you touch her skin?
I wouldn't have touched her skin, no.
All right, you did not do that. So your observations were nothing regarding lividity in this particular case. Is that correct?
That's correct.
And lividity, so that we're clear, is one of those conditions which one might use to try and determine the time of death. Is that correct? Along with other factors?
It's a very general indicator. I wouldn't depend entirely on lividity as a determined time of death.
I didn't ask you to depend entirely. I said, was that one of the factors that you might use to determine the time of death? Is that correct, sir?
One might.
All right. And what about you?
Again, it would depend on the circumstance. In this case, certainly not.
And that was because she lost so much blood?
Because she lost so much blood, there was no lividity that I could see, certainly on the back portion of her or her legs that were visible.
But you'd made no palpable or no touching of that body. Is that right?
I did not touch
All
her.
right. Have you ever read a book put out by the National Institute of Justice Research project entitled Identifying Plant Food Cells in Gastric Contents for Forensic Investigations, a Laboratory Manual? You ever read that?
No.
By Bach, Lane, and Norris?
No.
Have you ever read any publication at all about how stomach contents might be used to determine the time of death in individuals?
Read Lemoyne Snyder's homicide investigation that addresses that particular thing, but again, that's just one general indicator.
And Lemoyne Snyder, when did you read that last?
I've referred to it several times over the years.
When did you read it last?
Read it from cover to cover several years ago.
When was that?
Gosh, probably 10, 12, 15 years ago.
Is that the last time you read it?
Well, I refer to it from time to time. That'd be the last time I read it cover to cover.
And again, in that connection, you've told us that all these things are factors. But you take all these factors, whether lividity or stomach contents or whether the person had their last meal, and you put all those things together as an investigator, and you try to determine what the time of death is. Isn't that correct? Isn't that what you do? Can you answer that yes or no?
You attempt to, yes. But again, it's very general. Without an eyewitness, you're never going to be able to pinpoint the time of death.
We understand that, and if there are no eyewitnesses, we appreciate that. But what you do is you do the best you can with each homicide scene. Isn't that correct, sir?
Certainly do.
And what you do is you try to assemble a team of forensic pathologists, and you try to use that team. Is that correct?
That's correct.
And if there's evidence that might help you determine certain things, you try to preserve that evidence. You don't throw it away. Isn't that correct?
Well, you're always going to attempt to preserve evidence, certainly.
And you try to do the best you can to gather all the facts. Isn't that correct?
That's correct.
You've already shared with us that each case is somewhat different. Isn't that correct?
All cases are different.
Now, yesterday you described a term which you believed you call it a cast-off. You ever qualified as a blood splatter expert in any court in Los Angeles County before?
Yes.
How many times?
Twice.
And where was that?
In federal court once, and in the court of Judge James Basque, LA County Superior Court.
And when was that?
Approximately four years ago, perhaps.
Do you remember what the name of the case was?
Yes, it was the Kowal. Kowal was the victim. It was the Karamalis case.
Karamalis case?
K-A-R-I-M-A-L-I-S.
And with regard to this term, cast-off, have you read any publications on that particular term?
Yes, I've read
What'd you read?
books on blood spatter analysis, crime scene analysis.
All right, in that connection, does that have to do, what the term cast-off, does it have to do with describing the velocity with which a splatter moves from one object to another? Is that correct?
Not necessarily the velocity, it's just describing a droplet of blood falling from, say, a weapon.
All right, and can you tell by looking at a splatter whether or not the droplet was a free fall or it was thrown from a distance? Can you tell that?
Yes.
And you, in this case, did you make an analysis in this case at the scene that day?
As to blood droplets, yes.
Yes, sir.
As to this particular, are you referring to a particular droplet or all of the
Talking
blood?
about the droplet you talked about yesterday on Naron Goldman's shoe.
Okay,
Did you make an analysis that day at that time at the scene?
no.
Well, when did you make your analysis? At a later time?
As to the fact it was a cast-off,
That's your belief it was a cast-off.
subsequent to that date,
And when was that? When did you first make that analysis?
I believe after information became available as to the identity of the blood that was contained.
And when was that? Give us the month or the year.
Might have been September, October last year.
1994?
Yes.
Now, it's true, is it not, that the condition of Mr. Goldman's shoes changed after they were bagged by the coroner's office? So there were more blood on those shoes after they were bagged and taken to the coroner's office than there were before. Isn't that correct?
I wasn't aware of that.
You're not aware of that? Have you seen any pictures that would indicate that?
I wasn't aware of that.
Did you ever talk to any expert in the field, a blood spatter expert, regarding this cast-off theory that you told us about yesterday?
Yes,
And did you ever write a report in your book regarding your belief about the cast-off theory?
no.
Is that ever written anywhere in any of these volumes of books that you have?
As to that droplet being a cast-off?
Yes.
No, I don't believe it is.
And did you ever testify about that before in any proceeding in this case?
No. I was never asked about that.
So your first time you testified about that was yesterday, right?
This was the first time I was asked about it.
And did you answer yes? First time you testified?
That's correct.
And it's not written in any publication or any reports you've written in this case, is that right?
That's correct.
With regard to this so-called mixture of the victim's bloods, do you know whether or not there's a more concentration of one victim's blood over the other in this so-called splatter? Do you know that? You have no knowledge of that, do you?
No.
Now, you talked to us yesterday about the bodies being in a rather close area and that the evidence was close to the bodies, or the evidence was right around the bodies. You recall that?
Yes.
And in that connection, the criminalists in this case, as I recall, did not arrive until after 10 o'clock because they'd been over at Rockingham. Isn't that correct?
Yes.
Now, in some of the videos we've seen, we saw a man you identified, I think, as Johnson. Steve Johnson, was it?
Yes.
And he's one of the criminalists, a supervisor. Is that correct?
Yes.
The LAPD lab, SID lab, has more than 2 criminalists, don't they?
Yes.
And if you'd wanted to get other criminalists out there to start working on that scene at Bundy, you could have done that, couldn't you?
There was no need to, but I could have.
You could have done that?
Perhaps I could have, but I had expected the criminalists to come directly over from Rockingham.
And so when they got there after 10 o'clock, that was some 10 hours after these bodies had been found. Is that correct?
Approximately.
And at that time, since the coroners had finally been called, the coroners were there already when the criminalists arrived. Isn't that correct?
That's correct.
And then ultimately, you were present when these bodies were moved. Is that correct?
Yes, I was.
You described for us that your belief, let's strike that. Did you see the evidence move that we talked about earlier when the bodies were moved? Do you see that?
Once again, my answer was then and still is now. I did not physically see them move.
All right. But at any rate, the bodies were moved, and had the criminalists finished their work at the time these bodies were moved?
No.
So Fung and Mazzola continued to do their work after the coroners and coroners representatives took the bodies away. Is that correct?
That's correct.
Now, I want to show you part of a video we've shown before in regard to Mr. Fung and his presence at the scene there that morning on June 13th.
All right, which exhibit is this, Mr. Cochran?
It's 10:43, I'm advised, Your Honor.
Cochran. If you want to stand up and stretch for a moment, please feel free to do so. The audience can too as well. Mr. Cochran.
Thank you. I want to have you take a look at this portion of the video. I believe you've seen this before. Now, just that gentleman there with the, now stop it right there. Now, the man who's coming out of an area that you just went into, who is that?
It's Mr. Fung?
Is that the criminalist we've been talking about?
Yes.
And he has a bag in his right hand with no glove on that hand. You see that?
Yes,
And that's an area that you just went into, right?
that's correct.
And is that the area over wherein, the jury be familiar with the area where Mr. Goldman's body was found?
Yes,
Is that the area where, strike that, Mr. Fung is coming out of that area, is that correct? Is he about to step over Ms. Nicole Brown Simpson's body at that point? You can tell?
I can't tell whether the body has been moved out on the walkway at that point or not.
Well, do you see the man in the blue, and perhaps it may be one of the other body, do you see the man in the blue bent over Mr. Jacopo in
Yes,
the coroner's office? Do you
yes,
recall when you saw him there that day and working in that area on the walkway, he was working with bodies when he's at that location?
yes, but I can't tell which body is here.
All right, I understand that. But it's apparently one of the bodies, is that correct?
It would appear that way, yes.
All right. Your Honor, we printed out this particular photograph if we can earlier, if the court pleases, and may I ask the court to allow me to mark this as 10 or A?
1043A.
1043A, that's all right, Your Honor.
All right, and this
I've
is
shown it to counsel. 1043A.
counter.
Now,
Excuse me.
Sir.
This is counter 01181801 on the counter.
Well, I have on the photograph 1181807, Your Honor. So it may continue.
That's in hundreds of seconds.
Yeah, hundreds of seconds, yes. So let's take it to 7.
All right.
To 7.
There we
The
go.
photograph. So now we have it, Your Honor. All right, now, Mr. Lang, what does Mr. Fung have in that bag in his bare hand there?
I believe that's very possibly the right-hand glove from Rockingham.
Well, he had taken the right-hand glove from Rockingham into the area where Mr. Goldman's body was and where this left-hand glove was. Is that right?
I had asked him to look at the glove.
Can you ask that yes or no, sir? Had he taken the glove in there?
Unless I'm mistaken, this is very possibly the time that he brought the glove over to me to look at, yes.
So the question is, yes, he had taken the glove inside that area?
Well, again, I'm trying to be as accurate as I can. I may be mistaken, but I had asked Mr. Fung if I could look at the glove from Rockingham. He brought it over to me, and I believe that this very possibly may depict that. I don't know for sure.
Now, this morning when I asked you, didn't you tell us, well, strike that. Is it your recollection now as you sit here that you had looked at the glove in the bag at this point?
I don't believe-
on this counter?
I don't believe I did. I believe I looked at the bag at the evidence truck after he walked out with it, if this in fact is that time.
Well, what has he done just before this, if you know, with that bag?
I don't believe he did anything. If this in fact is the incident depicted here with the glove in the bag, he didn't do anything with it.
What was he doing over in the area where Mr. Goldman's body was?
Well, again, I don't know if Mr. Goldman's body is back there or not at this point, because I don't know which body is out on the walkway. I have no idea.
All right, let's continue on with video. He apparently stepped over something. Did that refresh your recollection? He stepped over one of the bodies at that point?
Yes, Fung? Yes.
See that? Back it up, back it up. Back it up. See that, can you see that drink? Somebody having a drink in their hand there? See
Appears to
that?
be a cup in someone's hand, yes.
A cup at 11834.29. Now, that's a violation of the rules you told us about the other day, isn't it?
I don't know where he's standing. If I had seen that, I wouldn't have allowed it on the scene. I don't know if the cup is full, if it's empty, and I have never seen that cup at the scene.
Well, you see the scene, you see the cup at the scene now, sir?
Yes, I do.
All right, and that's, the question was, it's a violation of the rules you told us about yesterday. Isn't that correct, sir?
I would not allow that on my crime scene. That's my same answer. That's
Well,
correct.
I'm saying, do you see yourself up at the top?
Never mind.
Okay. Do you see yourself up in the upper right-hand portion of this photograph?
I'm not looking for cups, Mr. Cochran.
I'm saying, do you see yourself at the scene, Detective? Can you answer the question, please?
I'm trying to.
Okay, would you answer? Do you see yourself on the video here?
Yes.
All right. Now, do you see the cup on the video?
Yes, I do.
All right. And that's a violation of the rules you told us about, right?
That's correct.
Do you know whose hand that is? Who had that
No.
cup?
No.
Continue on. See it again there?
Yes, Mr. Cochran, I saw it again.
Now, you notice, we stop for a moment. You see Mr. Fung there? He doesn't have anything on his hands there, does he? He has no,
Can't tell with that shot.
well, look at his right, on his right hip. You're able to tell he does not have any gloves on his hands at that point? You able to tell that?
No.
You can't tell that, all right? Continue on. You see his hands now? You see Fung's hands now?
Yes, does not appear to have gloves on.
That's it.
Frame 5119.
118, 51, 19 year.
Yes.
It's set. Thank you. Remember, there's another video that rather than show it, I think we showed it earlier, I want to just approach the witness and ask him to identify, and then I'll put it on the Elmo if the court will allow. You have shown us the counsel, so I'll mark this as defendant's next in order.
Mrs. Swerve.
104-3B. Show it to counsel here.
1043B.
104-3B, yes, ma'am. Now, Detective Lang, I'm going to place before you this photograph, which is a print actually, in video. Do you recognize the gentleman depicted therein?
Appears to be the photographer.
Is that Mr. Rokar?
It looks like Mr. Rokar, yes.
And in that photograph, can you see his camera there?
Yes.
His right shoulder?
That's correct.
And you see the line still up so that the crime scene is still intact at that point?
Yes.
He's inside the crime scene? Mr. Rokar's inside the crime scene?
Appears to be, yes.
All right, place on the Elmo, Your Honor. Now, that's a photograph of the photographer in this case, is that correct? You see his camera in his right hand, do you not?
Yes.
he apparently is looking inside of a mailbox there at the location?
It
that right?
appears that way.
Is that one of the jobs you assigned him that morning, to look inside that mailbox?
No. He may have been looking inside that mailbox to take a photograph of mail, however.
He may have been doing any number of things, but what we have is the photograph. Is that correct, sir?
When we have a photographer at the scene, we generally ask them initially to do orientation shots, and we do not supervise each and every one of them. I would certainly expect my photographer to show that initiative, and in this case, he appears to be showing that initiative.
He's showing you lots of initiative. Is that right?
He's showing me the initiative that he's looking in that mailbox, and if there were mail in there, I'm sure he'd photographed it and told me about it.
Have you seen any photographs of mail in this case, sir?
He would have known unless he looked.
All right. Can you answer one question? Did you see any mail in that mailbox?
No.
All right. And then with regard to that, you had a report about him opening the mailbox to look inside the mailbox.
No.
You didn't know anything about him doing this, so you saw the video, did you?
That's correct.
And do you know whether or not that mailbox had been dusted for prints before he did this?
I have no idea when this particular photograph was taken.
You have no idea whether he did this totally on his own, do you?
I believe, to me, it shows initiative that he did it. I have no idea when it was done.
That's not what I asked you, sir. Do you have any idea whether you have no idea when he did this, right?
That's correct.
And you not told him to do this, is that right?
No, I didn't.
The first time you became aware of this is when you saw this photograph, right?
Once again, that's true.
Do you know whether or not that mailbox had been dusted for any kind of prints at that point?
Same answer. I have no idea when this
All right.
photograph was taken, so
All
I
right.
can't give you that answer.
Thank you. Your Honor, we've marked that exhibit if the court pleases. And I would like also to mark 1043C is the photograph of the arm with the cup in it, which was at 11834.29. I placed that on the read.
1043C.
1043C, and we'll pass that on, Your Honor. Now, with regard to this white sheet or blanket that we saw this morning and we've seen before, you have seen blood on that sheet and blanket. Isn't that correct? Did you not?
Yes.
That blood came from Miss Nicole Brown Simpson's body, or an area of her body?
Yes.
Now, you alluded to, I believe this morning, the fact that there had been a walkthrough which you had participated in with the defense, I think in August, on about August 27th of 1994. Do you recall that?
Yes.
And at that time, a knit cap was pointed out to you. And did you ever see the investigator, McNally, who was there, try the knit cap on?
No.
And you weren't interested in booking that knit cap, were you?
I had no interest in looking at no.
All right. And have you seen these knit caps where there's one size that fits all?
I suppose there is such a thing.
And what happened to that knit cap? Do you know?
I'm assuming that the family
know what
collected
happened
it
to it?
with everything else. I did not follow up on the knit cap, no.
And what color was the knit cap, sir?
My recollection is either dark blue or black. I don't recall.
Appeared to be the same color as the knit cap that you allegedly found outside. Is that correct?
It was a dark color. I don't recall if it was the same color or not.
Did you take a photo of that particular cap that was pointed out to you that morning?
No.
Now, with regard to the children, we talked about this briefly. The police officer Vasquez overheard a statement wherein Sidney Simpson was speaking to her younger brother, Justin. Is that correct?
It's my understanding, yes.
And that statement is in a report provided by Vasquez. Is that correct?
I believe so.
And the subject of that statement deals with a phone call that their mother had received that night. Isn't that correct?
I don't know if it involves a phone call. I thought it involved an overhear on the part of Sidney. I'm not sure, though. I haven't reviewed it in some time.
An overhear of a phone call, sir. Isn't that correct?
Objection, Your Honor.
The subject matter you're not here to say.
What's the objection? Sustain.
Asking about the subject matter.
That involves hearsay. Sustain.
So did it involve a overhear of a conversation? That's not a hearsay. The
That's
overhear of a
not the
conversation is not
subject.
hearsay.
What went on is.
Yes. Did it involve an overhear of a conversation? Telephone
believe it
conversation?
did. I believe it did.
When's the last time you've seen Vasquez's report?
When you showed it to me in court several days ago,
All right, and she's still with the Los Angeles Police Department?
I don't know.
You don't know that?
I don't know.
In the course of your investigation, did you ever ascertain whether or not Nicole Brown Simpson received a phone call from Faye Resnick that night?
I did not have that information, no.
With regard to your theory of this not being a drug killing, would that ever be relevant to you, given the facts I gave you before regarding Faye Resnick, and whether or not there was a phone call from Faye Resnick at about 9 o'clock or thereafter on the night of June 12, 1994? Would that have been important to you as an investigator, from Faye Resnick to Nicole Brown Simpson?
Yes?
That would be important to you?
Well, I'd like to talk to Faye Resnick, not because I thought it was a drug-related murder, but anyone who spoke with the victim I'd be interested in.
Well, you talked to her at lunchtime today without giving us that conversation. That's the first time you've talked to her since you read the book?
I think he's already answered that question.
The book, Your Honor? I don't think I've asked that question.
Said he read the book when it first came out, and he told us about talking to her this afternoon. He's already told us about this.
All right, very well. When you were at Rockingham, it's your testimony that you came in the rear of Mr. Simpson's home. Is that correct?
Initially, yes.
And when you came in the rear of that house, you remember what order you came into the house, sir?
No.
And did Narnell Simpson come in first?
She may have.
What, did she have a key?
Seems to me she did key her way in.
And do you recall whether or not the alarm was on at that house at that time, sir?
No,
You don't recall?
that's correct.
You have no recollection of whether or not she had to turn the alarm off at some point?
She may have. My attention wasn't focused on her.
But at any rate, if she did it after she came inside the house from the rear, right?
I would assume that.
Now, yesterday you described during redirect examination how you allowed Detective Furman to interview Mr. Cato Kalin in his room. Is that right?
That's correct.
Did you specifically tell him to do that, or you just told him, you just didn't stop him from doing that?
It's the way things happened. He was walking in front of me. I was going towards the house to knock on the rear door. He walked to the guest house and knocked on the guest door. He was the one that happened to be there to do that.
Okay, now my question, let's get back to my question. My question was, you specifically tell him to do that at all?
Specifically tell him to knock
Go
on
and
the
interview
door.
Cato Kalin. Did you tell him to do that?
No.
All right. Yesterday, you indicated at some point in your examination, did you use the words, "I work for Van Adder"? Did you say that?
I work for Van Adder.
Did you use the words, "I work for Van Adder"? Was that in the transcript? Strike that. I won't put it. That's a bad question. Did you say that? I saw it in the transcript. Did you say that? "I work for Van Adder"?
In relation to testimony yesterday?
Yes, sir. In relation to testimony yesterday.
I don't recall saying that.
You don't recall saying that?
No.
Did you work for Van Adder on that date?
No.
You were co-lead investigators, is that right?
We worked as partners, that's correct.
We were asked a series of questions yesterday by Ms. Clark about, I believe, candles and the state of burning of those candles. And so that we're clear, there are no photographs of these candles to assist us now as we look back to try and determine how much they burn. Is that correct?
I have no photographs, that's correct.
All right. And not only you, there are no photographs in this case of those candles. Is that right?
I recently observed a video that has the candles in them, yes.
All right. Where'd you observe that video?
I believe that was a compilation of news releases, news stories, and news videos that we received from the defense,
What did you receive from the defense?
from you,
And you saw this, you saw a candle burning? In what room?
in the front room.
In the living room area?
Yes.
Is there any pictures or that you ever took of any candles burning?
No, I already testified. We took no pictures of the candles burning.
The only burning candle you've seen is a video turned over by the defense to the prosecution. Is that correct?
That's correct.
When did you see that?
When?
Yes. What date was it?
I believe it was last Friday night
Last Friday night? And where were you at that time when you saw it?
in this building.
And who were you with?
Myself,
By yourself, alone?
by myself,
On Friday night, watching videos?
by myself, alone, watching videos.
I won't say anything else about that. And you... Excuse me. Thank you.
I was asked to do it.
All right, you asked to do it by Ms. Clark? Okay. Well, explain that. Huh? And who asked you to do that?
Ms. Clark?
Ms. Clark? All right. Did she watch any of those videos with you?
No.
Now, yesterday, Ms. Clark went through an attempt to try and explain the 115, 116, 117 photo ID numbers and the evidence numbers. Do you remember that?
It is.
Well,
It is.
well-
It is.
Attempt, well, okay, I'll take out the word attempt. Yesterday, Ms. Clark asked you some questions about 115, 116, 117, and the photo ID numbers and the numbers assigned to evidence in this case. Do you recall that?
Yes.
As I understood what you indicated to us, you said that the answers to the difference between the photo ID numbers and the items that were assigned to evidence are located in the voluminous 30,000 pages of reports in this case. Is that what you basically said to us? I'm asking you.
It states the evidence.
What, you
States the evidence.
well, didn't you say the answer to the 115, 116, 117 was contained in the reports in this case? You say that?
I believe I said the property reports.
Yes. Did you say that? And among the reports in this case, there are how many pages?
Overruled.
Among the reports,
Overruled.
okay. Among the reports in this case, how many pages are there altogether, if you know? Property reports and all reports.
Objection, that's irrelevant.
Overruled.
As to the entire investigation,
Yes, sir.
several thousand.
Several thousand?
Yes.
You heard the term 30,000?
I don't know if there are that many. At least not generated by the police department after the case was filed. Of course, there was a lot more that went on.
Now, with regard to that glove that we saw, strike that. With regard to the bag that we saw on the video that we showed you regarding Mr. Fung, after having seen that, is your memory refreshed as to whether or not it was after we saw Mr. Fung stepping out of the area where Mr. Goldman was, that you then went out to the van and looked inside of the envelope, inside of the paper bag, rather?
Again, if this was the bag that had the glove in it, I would have done that. I don't know if this was that particular bag or if Mr. Fung was back there doing something else. It's unclear to me whether Mr. Goldman was still back in that position or not, so I can't give you a time frame and I can't give you an answer.
Well, did you see Mr. Fung at the scene that morning after he got there after 10 o'clock on the 13th with more than one paper bag as he appeared in the video?
I saw him with various bags at different times, yes.
Were the other bags that you saw similar to that bag?
Yes.
How many bags did you see him with at all that day?
I don't recall. I believe they put one piece of evidence in one bag, so I observed 2 or 3 bags in the area. I don't recall specifically.
Now, with regard to shoe prints at the scene there of that particular evening, we've had a lot of testimony about shoe prints leading and heading west of where the bodies were found. Were you ever able to determine or make any copies or take any photographs of any shoe prints that were in the dirt area where Mr. Goldman's body was found?
I observed none in the dirt area.
And in fact, we know, do we not, that you stepped in that area, did you not?
I did.
Detective Furman stepped in that area, did he not?
Appears that way.
And Mr. Fung stepped in that area based upon that video, isn't that correct?
That's correct.
At least those three. And there may have been others, isn't that correct?
Possibly.
And we know also that footprints aren't always, or shoe prints aren't always visible with the naked eye, isn't that correct?
I would say not.
Overruled.
Under these circumstances in the dirt, I examined it before I went in there, and I saw none. I couldn't imagine invisible prints being in the dirt.
That's not the question. I didn't ask you about in the dirt. I said shoe prints aren't always visible with the naked eye. Isn't that correct, shoe prints?
Overruled.
In the dirt?
No, I ask you, are shoe prints sometimes
Depends on the
not
surface.
visible?
Mr. Cochran, it would depend on the surface.
All right.
If you were to ask me that on a flat,
You've answered
smooth
the question.
surface,
You've answered.
No objection. No.
Overruled. It was just a question, are some
Shoe prints.
shoe prints not necessarily visible to the eye? Yes
Is that-
or no?
Yes, yes or no? Are some shoe prints not necessarily visible with the naked eye?
you're not referring to dirt strictly? I thought you were
Excuse me,
referring to dirt.
counsel. Also, we've covered this twice already.
I want to ask, go into a specific area, Your Honor. I want to ask this. I thought he had, Your Honor, but I'm not
This is
sure
about
now.
the third time we're visiting it.
I'm not
with
sure,
this
Your Honor, now,
witness.
based upon where the answer is.
I'm
I'm not
sure.
sure. Well, I'm sure we did cover it. I'm not sure of the answer now is what I'm indicating.
No, we got the same answer the last
Okay.
time.
May I ask this question again? Let me try to get an answer, Your Honor.
Quickly.
Are footprints and shoe prints sometimes not visible in the naked eye, depending upon the surface that they're on?
Yes.
All right? And with regard to the area of the dirt in this case, did you take any photographs or any photographs taken by you of any possible shoe prints that might be in that dirt area that morning?
There were none there, so there's no reason to take photographs.
So you didn't take any? You didn't take any photographs, is that right?
There was nothing to take photographs
All
of.
right. So that if Mr. Goldman's assailant had stepped in the dirt and there were no shoe prints, and he left out like you did and walked along that walkway trying to avoid the blood, there'd be no shoe prints for you to see. Isn't that correct?
I don't know. I saw none in the dirt.
Well, that's what you did, is it not? You stepped in there and you stepped out, tried to avoid any bloody shoe prints, did you not?
I did.
And since you weren't there, you don't know whether or not Mr. Goldman's assailant may have done that same thing. Isn't that correct?
Objection.
I'm asking you.
I have no idea what his assailant did.
Just like you have
Other
no
than
idea of whether
the
or not...
assailant, may I finish?
Hold on. Mr. Cochran, let him finish the answer
Thought he was finished, Your Honor.
before you start answering.
Thought he was finished.
The evidence clearly shows that the suspect went the opposite way because of the bloody shoe prints west on the sidewalk, not east on the walkway.
Well, sir, if you couldn't see the prints, how do you know that? You were not there.
I did see the prints. There were bloody shoe prints.
If
I
there
saw
was,
them.
if there were shoe prints that were not visible with the naked eye, how would you know that? You were not there.
That's argumentative, counsel.
All right. Now, in that connection, yesterday when you told us that Mr. Goldman was surprised by this attacker, that's a theory of yours. You were not there. Is that correct?
It's correct that I was not there.
All right, and that's your theory, is that not?
I believe there's a possibility that he was surprised, yes.
All right, that's a possibility. It's also a possibility he wasn't surprised. Isn't that correct?
The indicators to me are that he was, but again, as you stated, I wasn't there. I can't say.
And with regard to whether or not Mr. Goldman struck his assailant or assailants, you don't know that either, do you, sir? You can only tell us what your theory is that
I
correct?
can only interpret the evidence that I have for you.
All right, and the evidence you have, you shared with us, and you're part of the prosecution team, isn't that correct?
I am, yes.
Now, you talked about yesterday taking a statement from Mr. OJ Simpson. You recall that?
That's correct.
And when you talked to Mr. Simpson, he was cooperative, was he not?
That is a subjective thing. He was cooperative to the extent that he sat down and spoke with us, but
He didn't have to talk to you, did he, sir?
Objection. He's not finished his
I
answer.
thought he was finished. You may continue.
Oh,
I don't believe he was cooperative in being entirely forthcoming with me.
That's, again, your opinion, isn't it? Which you're giving us all day today and yesterday. That's your opinion, right?
That's argumentative.
All right. Well, there's a tape recording of this interview. Well,
Overruled.
all right. There is a tape recording of this interview, is there not?
Yes, there is.
It's about 33 minutes, is that correct?
That's correct.
The beginning of that interview, you tell him that he doesn't have to talk to you.
beyond scope.
I think, Your Honor, that this part, I'd like to be heard with regard to this part.
Well, we're beyond the scope of the redirect.
I'd last leave of court with regard to these series of questions, and I'll be wrapping this part up.
Counsel wants to make an argument.
All right.